Think we're live.
Good morning. We're back on the record in 25A-0355E Public Service Company Citing Permit Appeal, El Paso County. Mr. Mansholt, Mr. Martin, any preliminary matters, or should we continue with Ms. Parsons?
None from the county.
Oh, pardon me. The company has one preliminary matter, just a transparency update to all the parties. We are in the last leg of finalizing our conditions that we're going to be presenting today, and they're getting their final review probably within the next hour, 45 minutes. And so keep an eyes on your email inbox for us circulating that in advance today. Just wanted to give everyone a fair notice of where we are on putting that together for your understanding.
Greatly appreciate you moving so quickly. I understand there's approval processes and everything else, so thanks for that. Back to cross-examination of Ms. Parsons. I think you had 10 or 15 minutes left, Mr. Manchell.
Yeah, thanks for being here again, Ms. Parsons. Can you still hear me?
I can. I'm going to figure out how to turn my volume up. It's really faint.
Take your time, and I'll continue talking so you can play around to see if
Okay.
volume is where you need it or not. And what I was going to tell you first thing here is that I'm actually going to have very limited cross this morning, only like 5 or so minutes here, maybe 10 minutes. And for the behind the scenes court, I'm going to be pulling up one of the large attachments. That's the hearing exhibit 102 JLC5 Rev 1. And this one may take some time. It's one of the larger documents.
Did you want it now? I've got it open.
Yeah, if you do have it open, we can go ahead and share our screen on it. Is the volume better for you now, Ms. Parsons?
Yes, sir.
Great. And we're going to turn to page 2014. And here we have a transmission line routing map. If we go to the bottom of the screen, there's a legend to look at first. And Ms. Parsons, do you see that the yellow legend here identifies the proposed transmission route of the pathway project?
I do.
And while we're here, you see that there's another field for existing transmission lines.
Yes, sir.
Those are purple, green, blue, and red. So now we can scroll up and look at the route of our yellow pathway project here. And do you see the blue transmission line on the route? I'm sorry, on the map, Ms. Parsons?
Yes, I do.
And that's a 230 kV transmission line. Do you know who owns that line?
I do not off the top of my head. I would have to look at research and records.
Sure. Do you know if the county approved a 1041 siting permit for that transmission line?
I do not know for a matter of fact, but we didn't adopt our 1041 regulations until 2013, and I believe that line is a little bit older than that, if not much more older than that.
Okay. Do you agree that that line passes through the rural place type as identified in the county's master plan?
I do, however, the master plan was adopted just recently, I believe in 2019. I'm sorry, I did 2 master plans back to back. So I'm getting my water master plan and the county's master plan mixed up, but I believe the 2019 is the master plan, the current master plan that we have that identified place types.
Do you think that existing line represents a lower wildfire risk than Public Service's proposed pathway project?
Objection for speculation.
Mr. Mansholt?
Well, Ms. Parsons' testimony is all about wildfire risk. She has testimony thinking that the company's transmission line is too heightened of a risk for approval in the county. It seems very logical and fair. We can ask her about relative risk for wildfire for other transmission lines that are in the exact same location in the county.
Overruled, if you could answer, Ms. Parsons.
Well, yes, I'll start by saying number one, Mr. Mansholtz just repeat what he just summarized to you.
The question for you, Miss, is do you think that existing blue line represents a lower wildfire risk than Public Service's proposed power pathway transmission line?
I would need to review any studies or data and compare them to our land development code and work with the appropriate fire protection districts before I could jump to any conclusions, sir.
Okay. For that blue transmission line.
And sir, further, you stuck something in there that isn't really true nor valid. I have not said the risk is too high to approve. What I've consistently repeated in my comments was to provide more detailed information. And furthermore, I proposed a condition of approval that enabled the applicant to move forward if they provided a more detailed plan at the site development plan stage. So I just wanted to get that on the record because it felt like you were maybe twisting what was actually identified in the staff report very clearly in the wildfire mitigation section and in the conditions of approval.
Are emergency services like volunteer fire departments able to sufficiently address the needs for that existing blue transmission line?
I can't answer that, sir, without communicating with them.
Okay. Does that blue line cause unwarranted leapfrog development?
Again, sir, the current master plan that concerns place type and the approval criteria pertaining to 1041 was adopted post-construction of this. So you're basically asking me to apply new codes to an existing structure, which isn't really, we wouldn't do that in the planning world, and that you wouldn't do that in the building world either. It's not an answerable question.
Do you see the green transmission lines also on this map?
I do.
And you can see that towards the north there's actually some co-location with the green transmission line.
I sure see it, yes.
Do you think that these green transmission lines cross through the rural place type as identified in the county's master plan?
They do. And I think these are much
Do you think
smaller
these green
lines.
transmission lines, excuse me, miss, do you think these green transmission lines represent a lower wildfire risk than Public Services proposed power pathway transmission line?
I can't answer that without seeing data, sir, and reports.
Are emergency services like volunteer fire departments able to sufficiently address the needs for that existing set of green transmission lines?
Again, sir, I cannot speak for the fire protection districts. They need to speak for themselves.
Okay. And did these green lines cause unwarranted leapfrog development?
Again, sir, I believe those are existing lines that are pre the 1041 regulations and pre the current master plan.
No further questions. Thank you very much for your time with me. I appreciate it.
Thank you, sir.
Thank you, Mr. Mansholt. Commissioner Plank, questions for Ms. Parsons?
I have no questions for Ms. Parsons.
Commissioner Gilman, and if you could take down the map, that'd be great.
Yeah, hi, good morning, Ms. Parsons.
Good morning, Chairman.
Oh, I just got demoted.
Oh, I'm sorry.
He's fine.
I'm used to
It's
it.
still early.
Yeah.
Okay.
Yes, she did.
Just a
X.
few questions for you. The first is, from your understanding in the planning review of this, was there a consensus view of a better alternative route through El Paso County?
Throughout the process, from when the applicant first made contact with us, they actually started much more westerly in our El Paso County. And so we did work with the applicants and the public at the various public outreach meetings to push the line further east, where it wouldn't interfere with our major growth corridors. So this line where it's at as it's proposed is not in an area proposed as a growth corridor. So in the sense that we worked with the applicant to push it further east where it was less populated, I guess we could say yes.
Okay, so I guess what I'm hearing is what we're seeing in this final iteration of the location area is what was more preferable to the county than how that conversation started with something that was more westerly.
Yes, initially when the applicants came to us, they were proposing right of way along Curtis Road, which is one of our military access roads. So, and it is a planned growth corridor. So we wanted to work with them to encourage them to continue to move it out east, further away from those planned growth corridors.
Okay. And then I noticed in your staff report, you had indicated some potential conditions if the Board of County Commissioners did vote to approve the project. But you did not necessarily recommend denial of the project. Is that just something your department never takes aside, approval, denial, or in certain permits, do you suggest denial if you don't think they're appropriate?
Yeah, that's a great question. And since 2015, our department has taken the stance that we will be objective and just review an application against the criteria that's appropriate, state where it meets it and where it may not meet it, and then try to continue to work with applicants and propose conditions of approval so that if the board does elect to approve an item, we can mitigate an area that they may not be necessarily compliant. And so the bottom line is staff does not make a recommendation of approval or a denial, but we do make a recommendation for conditions and notations to offset any mitigation or any impacts to residents or environmental standards or other issues in the county. Does that make sense?
Yep, got it. Yep, so it sounds like your report is then positioned such that if the Board of County Commissioners does approve a project, you've laid out the conditions that you feel mitigate best the impacts to the county.
Yes, ma'am. And in this case, we had also been working for almost a year with the applicant on a specific development agreement, which is very standard with 1041 projects. And that development agreement is separate from the conditions that were recommended. The development agreement is specific to offset any impacts to county infrastructure, road, bridges, drainages, so that the taxpayers of El Paso County aren't paying for development, but rather the company or the applicant would be.
Understood. So if you had seen approval through the Board of County Commissioners process, you would expect both the development agreement conditions or agreements in addition to the suggestions you had put in your staff report for the conditions for approval.
Yes, ma'am. We did attach that development agreement to that staff report so they could be approved at the same time.
Got it. Okay. Thank you. And then I understand from some of your testimony yesterday, the company submitted, I'll give you a second.
I'm sorry, I'm going to dance.
Yeah, no, I appreciate the energy efficiency efforts on your side.
I apologize. This is not.
All right.
I apologize.
No, you're good. So I understood, yesterday, that what we have in terms of a more specific wildfire, response plan from the company is, county specific. Is that a fair description of what we have and what's in the record and what's been provided to the county as a more specific plan?
I'm sorry, could you say that over again? I apologize. I think I got
No, you're good.
dazzled with the light going off.
The company submitted a county-specific wildfire response plan, right?
They identified a wildland fire site-specific plan as a document. However, based on Chapter 6 of our Land Development Code, there were some things missing out of that document. For instance, Colorado State Forest Service has maps of historical fires, and that's one of the documents that would be identified in a more detailed wildland fire or more specific mitigation measures. And so at that public hearing, the Board of County Commissioners, I can't remember which commissioner brought it up, but there was a large discussion about these cameras, and that would have been a mitigation effort. However, they didn't discuss those cameras being an option in the site-specific component of their staff report. They did depict a map of a cameras in Pueblo, and further west, near the city of Colorado Springs, which is more than 45 miles away. So it may have been a different outcome had the plan included more site-specific mitigations, correspondence with the fire protection districts that were very specific to how those districts can accommodate a wildland fire or a electrical hazard in that area. But we just didn't have that, which is why I was so willing to work with the applicant to say, hey, let's just defer this to the site development plan and get you moving forward.
Okay. And did you understand at the time of your staff report and the Board of County Commissioners hearing that county-specific wildfire response plan had been filed by the company prior?
Yes, I did. And if you, in the paragraph on wildland fire in my staff report, I identify that there's one submitted, but we need a further one at the site development plan.
And the one submitted that you're talking about was specifically what they had labeled as the site-specific wildfire plan rather than a statewide plan.
Yes, and it encompassed both the statewide plan that they had submitted to the PUC that I believe hadn't been adopted yet, and combined that with the first 20 pages for the site-specific, and it was uploaded May 7th by the company.
Okay. And then I want to better understand the county's expectations around coordination with the local fire districts. If what we're seeing here is that there was an attempt at that correspondence on the side of the company, but 2 out of the 3 had not responded back by that time, what are your further expectations with regard to permit approval if that correspondence is not being met with a return correspondence?
That is a really good question. In the past, in the last, going back to, I'd say 2017, we haven't had the situation where the applicant wasn't working directly with the fire protection district throughout the process. And usually that first contact is starting publicly at the neighborhood meetings. So in this case, Hanover Fire Chief was at all of the meetings that Excel had, and I don't recall any fire chiefs that the line is actually proposed to be in. And that's really typical that we would see that. So this was a very unique and different process that the fire chiefs weren't starting working with the applicants from the get-go. And I can't defend or say why that didn't happen because I can't speak for those districts.
Okay. And then I think you had mentioned, and I got your maybe primary area of expertise was not in the wildfire, but I know that you discussed it somewhat. So I'm trying to understand with regard to the site-specific wildfire response, what specifically is missing that is, I think you had maybe mentioned a few things, but I just want to make sure I got them. What specifically is missing that the county typically requires?
Well, typically we would get a letter from the fire protection district that basically would cover, hey, we've worked with them. We're prepared to handle what they're proposing and we've got it covered and we know this equipment. So that allows staff to kind of, if you will, back off on the wildland fire, the fire protection report at this stage. Again, in this situation, we didn't have that. So I held a more steadfast line because I wasn't getting that correspondence back as requested, that the applicant meet the land development code in chapter 6. So water supply, water sources. Remember, this area is very rural. It's gravel roads. They're a little rough, not necessarily maintained to an urban standard for sure. Response times are unfortunately very long, not only from fire protection districts, but from ambulance services and our sheriff's department in this area of the county. So here we had a much unique, a little bit more of a unique situation where addressing those types of situations would be more relative. Again, I've already mentioned that there is a requirement in chapter 6 to include historical fire data in the area. And so that data is available on Colorado State Forest Service websites, which is where the applicant, I believe, got their burn probability map that indicated, they're in a moderately low area and then in the northern part of the line in El Paso County and a low area on the southern portion of El Paso County. So again, I mean, water source is pretty important. Time response. Does the fire protection district have those equipment? Do they have the training? Do we need cisterns along the route so that they can pump water, or how? We just didn't have those answers. We didn't know if there was going to be cameras. We just didn't have enough information, and we didn't have the support of the fire protection districts, and unfortunately at this time, in terms of communication, I should say.
Okay. Thank you. Those are my only questions. Appreciate it.
Okay. Sorry, I hope I answered them for you. I tried.
Great. Thank you.
Thank you, Commissioner Gilman. And you're welcome to run the rest of the hearing if you'd like.
Okay, I'm not responsible for that in any way. I'm so sorry.
Yeah, no worries. Just a couple clarifying questions. You mentioned a development agreement with a company. In your view, is that agreement self-enforcing on its own terms, or is it only enforceable if the 1041 permit was approved? So example, if they don't repair the roads as they committed to do, is there an enforcement mechanism in the development agreement, or is it only a breach of the conditions of the permit approval? And, I know you're not a lawyer and, your counsel can answer in its statement of position, but do you have any sense if that a development agreement is self-enforceable, or to enforce it, we'd have to take action here?
At this time, the development agreement was not approved with the 1041. The development agreement does require the chairwoman, Commissioner Geithner's signature to be finalized. So I'm not an attorney, but I believe we would need the county signature on that development agreement to execute. And then the follow-up component of that is there was some collateral that would have to be required so that we were ensured that we could go out and fix. For instance, if there was a significant pothole that was created, maybe just from continuous truck traffic, we could get out there and fix that and bill and take out of that pot of money, if you will. Is that what you are asking me?
Yeah, that's helpful. So are you sitting on a signed version of the development agreement? It's signed by Excel, but not signed by the county. Is that sort of the status of that?
Yes, Chairman. It was attached to the staff report. And so, yes, in theory, if the Board of County Commissioners would have approved the 1041, the chairwoman would have signed the resolution that I had attached and that development agreement, and we would have recorded it. And then we would have moved forward with the applicant submitting the site development plan and associated documents, collected that collateral, issued a construction permit, and they would be on their way.
To build out the record in the event the commission wanted to develop a set of conditions that could potentially apply to this transmission line development if it were to move forward, any thoughts about what the county would like to see in those conditions over and above what you recommended in your report? Or said another way, are the recommendations in your report comprehensive? Would staff have been comfortable with this project moving forward if those conditions were binding and enforceable, or would you like to see other conditions?
That's a tricky question because I don't dare speak for our elected officials or our Board of County Commissioners. Staff was confident in the staff report that I wrote with the combination of the development agreement corresponding to the recommended conditions of approval. Is that a fair response without speaking for an elected official?
Well, I guess we got an elected official coming, so so it sounds like Ms. Geithner is the best person to from the county to talk about the conditions, because she's speaking for the board and you're in an awkward position as staff. Is that a fair characterization of who speaks for the county? It sounds like it.
Yes, I believe that is a very accurate description.
All right. Mr. Bell, redirect.
Yes, thank you, Commissioner. Ms. Parsons, thankfully, Commissioner Gilman's questions did away with a lot of my redirect questions, but I do apologize if I am repetitive in some certain areas. But you went over what was referred to as a commitment letter. Do you recall that line of questioning?
I do.
Okay. Are any of the considerations that you employ to determine whether a wildfire mitigation plan is sufficient, are any of those considerations normally covered by the submission of a commitment letter?
They are. It puts the assurance that while the project, whether it's a power line or a solar field or any other relative 1041 application, it puts the responsibility back on the district that they've reviewed the project and they have the equipment, the material, the training, and the means to deal with any emergency responses that would come up from a result of the construction of the project.
And in your experience, what does it mean if there is no commitment letter submitted with an application or during the application process?
It's a tricky question because this is not a common thing. As I mentioned, we typically will have those coordination or commitment letters from a fire protection district when we're talking about a large project like this, or even a final plat in some cases. So I'm not sure. Can you repeat that question?
Yeah, and it's very possible that it was very poorly worded, so I do apologize for that. But in your experience, if you don't have a commitment letter submitted to you either with an application or during the application process, what does that tell you, or what concerns would you have with that lack of submission?
It concerns me in the sense that I don't have the ability to state that the fire protection district is able and aware of the project and can deal with an emergency, whether it's a fire or an electrical. And again, I am so sorry about these lights, but it concerns me for public safety, health, and welfare of the citizens, because we don't have any assurances that the fire protection district can protect these people based on this infrastructure if we don't have the commitment letter or correspondence. I'm gonna go open the door again and hope the light goes on again. I'm so sorry.
I was going to say, as much as we love to save energy, I don't want you to sit in the dark.
Sorry.
Oh, perfect. Kind of stemming along the same lines, we've heard some testimony in regards to the January 26, 2026 public comment hearing. Were you present at that hearing?
I was not present.
Have you had the ability to watch a recording or review the transcript?
I did watch about 90% of the meeting.
Were you able to listen or review Fire Chief Hicks's comments?
I did hear his comments.
Okay, do you know where Fire Chief Hicks is employed?
I believe he is Edison Fire Protection District.
Okay. Can you summarize Fire Chief Hicks's comments?
Yeah, it's both hearsay and it's not relevant to anything that was asked in cross-examination.
Mr. Bell,
So,
tend to agree, but
yeah, I think it's important because it sheds light on kind of the company's conferral with the fire districts. This was a comment that was made at a recorded public comment hearing. Hearsay defined is an out-of-court statement. This statement is in the record. It was before the PUC, and getting El Paso County's response and impressions of the comments made at those hearings, I think is fair game.
but how's it consistent with redirect? The scope of redirect has to be consistent with the cross. It seems like you're now beyond the redirect.
I can move on, Commissioner.
Okay.
Ms. Parsons, Commissioner Gilman was asking you questions about what was missing from the company's fire mitigation plan and fire prevention plan. Do you remember that line of questioning?
I do.
Did you summarize what you identified that was missing in that fire mitigation plan in your staff report?
I didn't summarize. What I did was highlight a few items that needed to be addressed further. And I specifically and very typically will use not limited to in my preface, I think it was like the sentence in the last paragraph of the fire hazard. If you want to pull up the staff report, can we pull up the staff report, please?
Yeah, of course. That's going to be Exhibit 102, Attachment JLC 8.
And then if we could go to my summary write-up on wildfire mitigation.
What page did you say that was? Sorry.
I believe it may be page 5, but I'll let Ms. Parsons correct me if that's incorrect.
Could you, I'm sorry, I don't have the exact page memorized, but could you scroll down a little bit and I'll ask you to stop when I find it. And I apologize for not memorizing the pages.
Is there a term I can try to control F and search to find it a little faster?
I think it's going to be either the next page or the following. We're in the criterion, so should be right after agricultural impacts. There it is, number 7.
So, Ms. Parsons, now that the staff report is in front of you, can you walk us through just at a very high level what you identified in your staff report in terms of the deficiency of the wildfire mitigation plan that was submitted to the county?
Sure. Well, I pointed out that the applicant's response to staff was that the company doesn't typically submit site-specific or county level fire plans, and I quoted it from their application. And then I identified that El Paso County's Fire Safety and Wildfire Mitigation Program Manager recommended that a detailed fire protection plan and wildland fire and hazard mitigation plan is submitted with the site development plan and/or construction drawings.
Can you slow down, please?
Oh, I'm sorry. I'm nervous. I apologize. The fire protection plan and wildland fire and hazard mitigation plan should include, but are not limited to, addressing wildfire management, considering the terrain, roadway infrastructure, response times, limited water sources, and vegetation in the area. And so in reviewing the plan, the site-specific plan that the applicant submitted on May 7th, I didn't see that level of detail in the plan. And so I agreed that we should just defer it to keep them moving along to the site development plan where they had the opportunity to submit a more site specific, and in hopes that they would actually be able to work with the 3 fire protection districts to ensure cistern placement, water sourcing, if new equipment needed to be supplied, cameras, etc.
Thank you, Ms. Parsons. We can keep this exhibit up because it's going to segue into my next line of questionings involving the master plan. Now, you were asked by Excel's counsel a lot about the master plan. Do you remember that line of questioning?
I do.
Okay. Do all utility applications need to comply with the county's master plan?
Utility applications, whether it's an approval of location or a 1041, do have to address the master plan and to address the review criteria for a particular 1041 or approval of location. So yes.
Did Piesco or Excel's application comply with the county's master plan?
Their application did address the master plan. However, staff determined that there was cause for concern in terms of leapfrog development and compatibility with the agricultural and rural lifestyle or character of the eastern El Paso County region.
Can we go to page 5, please? Is this, it looks like we're on page 5 of exhibit 102 JLC 8, and underneath approval criteria is on this page where you talk about the master plan and the compliance with it.
This is the page where I list out all of the review criteria that are applicable to this particular application. 2A specifically is that conformance of the project with these plans may include, but is not limited to, the following considerations. A, likelihood that the project will or will not cause or contribute urban sprawl or leapfrog development. So my role would be to analyze the application to this criteria and make that determination. And because we had already had an influx of early assistance meetings for solar providers and one wind energy company to kind of piggyback on to the power line or the transmission line and start changing the rural character of this particular area, northern area of the county, northeastern area of the county, I concluded that it definitely was potentially creating a leapfrog development situation.
Can we go to the next page, please?
The next page is criterion number 4. The project is not subject to significant risk from natural hazards. The determination of risk from natural hazards the project may include, but is not limited to the following. Faults and fissures, staff was not concerned with that. The applicants did submit a geology report. It was reviewed by the Colorado Geological Survey, and there wasn't significant concerns there. Unstable slopes, landslides, rock slides, and avalanche areas, again, there was not concerns there. Evaporative soils, risk of subsidence, there were no concerns there. Wildfire hazard areas, again, there was an area of concern. The Colorado State Forest Service maps for burn probability indicate moderate low in the northern eastern part of the line. And then the fuel type on Colorado State Forest Service has a moderate burn in this region of the county. And then also on Colorado State's Forest Service, unfortunately, there is a history of fires that are started not by the federal government, but it's categorized as just non-federal fires that are started along the route of the power pathway line. So based on the information on the Colorado State Forest Service website, which is referred to in our land development code in chapter 6, I concluded that we just didn't necessarily have enough information to make this criterion complete. Again, which is why I recommended that we provide an option for them to do the site development plan and provide a more site-specific wildland fire protection plan and continue to work to coordinate with those fire protection districts.
Beneath that criteria, it looks like C15, the project will not have significant adverse effect. Did that play into your assessment of the application in comparison to the master plan?
Well, we couldn't determine that, again, because our fire protection districts, which are a governmental agency, two of the three were not playing ball, if you will, or they weren't coming to the table. So we can't determine this because we just don't have the communication in the record or in EDARP or application that any of this occurred.
And do you have any control over the fire districts responding to XL?
No, the fire protection districts operate independently of El Paso County, and certainly very independently of planning and community development the El Paso County Planning and Community Development.
Can we go to the next page, please? Ms. Parsons, criteria C18 there. In relation to the project will not significantly degrade existing visual quality, can you walk us through how you reviewed the application in comparison to the master plan in regards to this element?
I can. So the criterion here is that the project shouldn't interfere with view sheds and scenic vistas. Additionally, in our master plan, I'm trying to memorize it, but I think it's on page maybe 128 or 129. We talk about preservation of our scenic vistas to consider that when we're looking at development. Pikes Peak, as you all are probably aware of, we have Americans Mountain. And so from our eastern boundary of El Paso County, as you look to the west, that is what you see, the beautiful Front Range. So if you are west of the line, arguably there would be no impacts or little impacts from the line. However, if you happen to be east of the line, there could be an impairment to the scenic vistas, or there could be some visual impacts.
Can we pull up Exhibit 108, which I believe is the master plan?
Sorry.
Great, thank you. Ms. Parsons, we also, you also faced several questions regarding specific place types and development areas in the county. Does the county recognize anticipated growth areas?
We do. So in our, aside from place types and key areas, we have a
And I'm sorry, Ms. Parsons, could we go to page 24?
could you, I'm sorry, do you mind staying on this page? So the eastern area of the county is cited as minimal change or undeveloped. And so if you zoom in, I can read you what that is slated for Eastern El Paso County.
Which part do you want me to zoom in on?
I'm sorry, the minimal change undeveloped. Thank you. Thank you very much. So undeveloped, please. Thank you so much. So more specifically, the character of these areas is defined by a lack of development and presence of significant natural areas. These areas will experience some redevelopment of select underutilized or vacant sites adjacent to other built-out sites, but such redevelopment will be limited in scale so as to not alter the essential character. New development may occur in these areas on previously undeveloped, but overall there will be no changes to the prioritized rural and natural environment. So that was also a consideration when we look at the master plan and this application.
And when you read this language and compare it to the application, does it comply with this or does it run contrary to it?
There would be concerns that because of the leapfrog development that it would create potentially, that it would in fact undermine the prioritization of the rural character and agricultural lands of Eastern El Paso County.
Why does the county have concerns with leapfrog development in general?
That is a loaded question. Let's see. Leapfrog development is not just relative to urban sprawl. When we have large, vast lands such as agricultural and an actual economic structure that is created by agricultural industry, and we remove that and put in a non-compatible land use, such as a large-scale utility generator, into that area, we have completely decimated the character of that. It's no longer going to be able to be used for agricultural. That economic viability is gone now. So that is why there could be a concern for continuing to allow leapfrog development in certain areas of the El Paso County. I would add that if we were looking at a development along a major highway and it was strictly along that corridor, there's language in the master plan that would perhaps justify having leapfrog development along like Highway 94, for instance, or Highway 24, because that corridor in itself already is not necessarily compatible with the agricultural areas. But this line isn't running along those east-west highways, if you will. It's actually bisecting them and running north-south. So it's a very different situation where it is actually setting the stage to have leapfrog development by encouraging and promoting solar and wind development in areas that are not along a major roadway corridor, that are in an area that we wouldn't anticipate development along a major arterial. Does that make sense?
It makes sense to me. I hope it makes sense to the commissioners, but otherwise, Those are all the questions that I have for you, Ms. Parsons.
Thank you for joining us, Ms. Parsons. You may be excused.
Okay, thank you. And again, sorry about the demotion.
No worries. I'm just teasing. Ms. Shields. Is Miss Geithner there?
Commissioner, we are going to be swapping out witnesses very quickly because they'll be in the same room. Can you give us 5 minutes to set up our next witness?
Yeah, let's take a break till 9:55. Thanks.
Thank you, Commissioner.
Ms. Geithner, are you out there? Commissioner Geithner, there you are.
Hello.
Hey, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No,
If that changes, will you let us know?
will do.
Back to you, Mr. Bell, Mr. Martin.
Good morning, Chair Geithner. Can you hear and see me?
Good morning, I can.
Great. Could you spell or state your name and spell your name for us, please?
Sure, it's Carrie Geithner, Carriegeitner.
And by whom are you employed, Ms. Geithner?
El Paso County.
In what capacity?
I am the elected commissioner for District 2.
Great. Did you cause to be filed in this matter, hearing exhibit 203, Madam Chair?
I'm sorry, I couldn't hear you. Could you repeat that?
Did you cause to be filed in this proceeding, hearing exhibit 203?
Yes, sir.
Do you have any revisions or changes to that testimony?
I do not.
And if I asked you those questions today, would your answers still be the same?
Yes, sir.
Witnesses available for cross-examination.
Ms. Shields, I have 90 minutes, although Mr. Manschultz seemed to think it would be less than that. Chair Geithner is available.
Great, thank you. And we will try. I do think we may have some other refinements to our cross times as the day goes on, but good morning, Ms. or Chair Geithner. My name is Caitlin Shields. I am counsel for Public Service Company of Colorado. And I think as we've all mentioned, I understand you are the chair of the El Paso County Board of Commissioners, or BOCC. Is that correct?
Yes, ma'am.
Okay. And am I correct? You've served in that role for approximately 5 years?
I have served as a commissioner for just over 5 years. Yes, not the chair.
Okay. And how long have you served in the chair role?
It's been, sorry, I'm doing some math here because I took over at the end of a year. So just over a year.
Okay, thank you. And I really appreciate you being here today. I know this is a challenging issue and appreciate your service and your time here. Have you been listening in on the hearing through yesterday, just for context? Have you been listening kind of since yesterday or not?
No, I haven't been listening in on the hearing. I've had a very busy schedule.
Understandable. Okay, well, thank you. Now, in your role as chair, am I correct? You oversee the process and procedure for El Paso's BOCC meetings. Is that correct?
Yes, ma'am.
Okay, and so part of the BOCC's responsibilities include evaluating local siting permits, like the 1041 permit that we're here about, correct?
Yes, ma'am.
Okay. And am I correct? This is the second 1041 permit that you have overseen and voted on. Is that right?
Yes, I believe so.
Okay, and that's during the course of your 5-year tenure as a commissioner, right?
Yes, ma'am.
Okay. So I assume you're familiar with Public Services 1041 permit application that is at issue here today, right?
Yes, ma'am.
Okay, and so although you haven't chaired the board through the full 1041 process, you have been involved and on the board and chaired it for at least the past year of that process, including the July 24th hearing where you voted to deny the permit.
Yes, ma'am.
Okay. Prior to voting to deny the permit, did you review Ms. Person's staff report?
Yes, ma'am. I reviewed the backup materials that are always provided for to commissioners prior to a hearing.
Okay, and you reviewed the proposed conditions that Ms. Parsons included in the staff report, correct?
As I said, I always review all the information that is provided as a part of that packet. So yes, I would have reviewed that at the time.
Okay, and so instead of voting to approve the permit with any conditions, instead you voted to fully deny the permit, correct?
Yes, ma'am.
Okay. Now I'd like to start a little bit by breaking down the full 1041 permit application process, in particular focus on the full process that unfolded here for this 1041 permit. And so you're aware the permitted issue here involves approximately 45 miles of new transmission line, otherwise known as part of segment 5 of the Pathway project, right? And when I say 45 miles, I mean within El Paso County.
Yes.
Okay. If we could pull up hearing exhibit 203, this is your answer testimony at page 6, just in case you need a reference point. And here on this page, you provide a general overview of the 1041 permit process, right? So based on what you include or what you've testified, you summarize that first, an applicant participates in an early assistance process with county staff. Second, an applicant submits a draft application. And then I think you indicate next that the staff and applicant will go through a series of back and forth processes that repeats itself until the application is complete, right?
Yes.
Okay. And so what I'd like to focus in, the question asks you to provide a general overview of the process. So you would agree that the actual process that has played out with public service has been more expansive. There have been many more touch points than simply what's laid out in your testimony right here in this short summary, right?
I can't speak to all of the touch points because commissioners are not involved in all of those touch points. I know the general process, and that's
Okay.
what I provided.
Okay, that's helpful. And so what I'd like to do is get into a little bit more detail, in particular that point that you just hit on, to further understand where commissioners are and are not involved in that process. And so I think what may be helpful here is if we could pull up hearing exhibit 102, attachment JLC3. And while we're pulling that document up, Chair Geithner, are you aware that before the company began, kind of jumped into the process where you started, which was the early assistance process, are you aware that the company and El Paso County representatives engaged in a number of meetings and a number of interactions?
I would say that that would be a normal thing to happen, to engage in those,
Okay.
but again, I don't have any specific knowledge of those.
Okay. And so just to give you some context for the document that's on the screen, this is a document that Ms. Chester provided. It's in the evidentiary record and summarizes the various timeline of meetings and engagement that the company public service had with county representatives. And so are you, to the best of your knowledge, the county does not dispute the various timelines that the company has presented? For instance, the 6 meetings that public service and county representatives held prior to the early assistance meeting. Is that right?
I would say to the best of my knowledge, but again, I do not get engaged in that, in those type of meetings, so I don't have any specific knowledge of that.
Okay, but you have no reason to dispute that there were, in all likelihood, multiple meetings between county representatives and the company leading up to that early assistance meeting.
I do not.
Okay. Now in her testimony, if we could pull up hearing exhibit 102, Ms. Chester's direct testimony revision 1 at page 25. Are you aware of that the company went through a fairly detailed siting study and routing study before it initiated the early assistance meeting?
I don't know the exact timing of that, but it was referenced at the hearing that there was time spent on that routing study, yes.
Okay, and so this document that we've pulled up. This is the segment 5 routing history. Again, Ms. Chester presented this in her direct testimony. Does this document look familiar to you?
I don't recall this document in particular. There's a lot of documentation that we review, and it's been quite some time, but I obviously see it on the screen in front of me.
Okay, and so that said, again, you have no reason to disagree with the company's testimony, nor has the county challenged in testimony that the company spent approximately 2 years going through a detailed siting study for segment 5 and within El Paso County. You have no reason to dispute that, correct?
No, ma'am.
Okay. And so you have no reason to dispute the company's indication that it evaluated over 1,200 miles of route options within 4,300 square miles for segment 5 alone. No reason to dispute that.
No, ma'am.
Okay. Nor the number of public meetings, virtual town halls, or open houses that the company conducted, correct?
No, ma'am. No reason to dispute those.
One of the, were you listening in on Ms. Parsons' testimony this morning?
No, ma'am, I was not.
Okay. One of the things that she indicated was that the county, and perhaps this was county staff, but she indicated that the county, and this was during an exchange with Commissioner Gilman, the county worked to push the line farther east to avoid major growth corridors. And are you personally aware of any of those interactions between county representatives and the company to work on a route that would move the line further east during the siting process?
No, ma'am. As I said, that there are many interactions with staff, but generally speaking, the commissioners are not involved in that process until it comes in front of us at the hearing, at the time of the hearing. And that is primarily because commissioners are required to come to those hearings neutrally. And so we don't generally participate in any of those things prior to that, to make sure that we can remain neutral and are only considering what is in front of us at the hearing, as is required by law.
Okay, that's really helpful. And so nonetheless, you have no reason to dispute or disagree with Ms. Parsons' testimony that county staff may have worked with the company to push the line to a more eastern route.
As I said, I have no knowledge of that, so I don't.
Okay. So we can turn back a little bit here and let's so I'm trying to figure out now the stage where perhaps maybe you as a commissioner become a little bit more involved. If we could pull up Hearing Exhibit 105, Attachment JLC 12. And I appreciate this is one of our larger documents. And I think while we're working to pull this document up, Chair Geithner, I will represent to you that this is the company's initial 1041 permit application that was submitted to El Paso County on June 4th, 2024. And if you see this document is 916 pages. So again, this would have been the initial permit that the company submitted. Would you have seen the initial permit application at the time that the company submitted it?
I would generally do not see those and do not recall seeing it when it came through.
Okay. Do you, as a commissioner, have access? We've talked a little bit about the EDARP system, the filing system you all use. Do you have access to that EDARP system, or do you receive documents as they're uploaded with the ability to review them?
The EDARP system is a public system, so
Mhm.
it's available to the public generally. However, as I stated, as a result of our legal requirements to come to projects neutrally, to review the materials that are presented in the hearing, and make a decision based on that hearing, I generally don't go looking for documents outside of that process.
Sure, understood. Now, if we could scroll down to page 4, and I apologize if I don't recall if I asked you this question, but do you recall having at some point seen this permit, the initial permit application?
Again, I don't recall seeing the initial one at any point. Again, we
Mhm.
review the materials that come with the hearing materials, but generally that is all that we review.
Mhm.
And that those records are very substantial, but I don't recall this particular document at this time.
Okay, no, that's helpful, but you have no reason to dispute that this 916-page document submitted to the county on June 4th was the company's initial permit application.
No, ma'am, I don't have any reason to dispute that.
Okay, so I think in your answer testimony at page 6, one of the things that you say is that throughout, and again, I'm not sure whether it's as of the time that the early assistance meeting happens or the initial permit application goes in, but from a process perspective, you've indicated that planning staff and the applicant engaged in a series of submittals, planning staff comments, and questions. Then your last night, that back and forth process repeats itself until the county deems an application complete. So in this case, as part of the back and forth process, that involves a series of referral comments. Is that right?
I would say generally that is how the process works, yes.
Okay. And my understanding of those referral comments is that basically what county staff will do is they take what the company has submitted, county staff will review what the company submitted, and then they will also send the company submittal out to other pertinent agencies or bodies who have the ability to provide feedback and ask questions. Is that an accurate summary?
Yes, I believe that's accurate.
Okay. And then the company has the ability to respond. And I think what you're getting at, and I make sure that I'm accurate here, that back and forth process, basically those referral comments go, as you say, back and forth until the county believes that an application is complete, at which time it comes forward to you as a commissioner. Is that right?
Yes.
Okay. And so in this case, the company and staff engaged in 4 series of referral comments. Does that sound right to you?
Again, I'm not very familiar with the process of what staff does before it comes to the hearing in terms of the specifics, numbers of time, dates. That's not something that we generally spend much time with.
Okay, so in this case, when there were 4 rounds of these back and forth referral comments, would you have at any point received the referral comments and the company's responses? Is that something that you see, that you have access to, or that you're typically involved in? Or again, well, I'll let you answer that question.
I would say it depends on what it is. As I said, anything that's provided in backup materials to the commissioners is what commissioners generally review before the hearing. In some cases, there are pieces of information, especially when other agencies are asked to weigh in, those things often come up. But again, I can't say that every back and forth piece is always submitted into that packet.
Okay,
And to be clear, I don't compare what is submitted to what those materials are. So I just I can't guarantee you that it happens. But I can tell you that oftentimes there are pieces, especially from those outside organizations, that are presented and that are specifically addressed at the hearing.
okay. If we could pull up hearing exhibit 102, attachment JLC 7. And while we're pulling that up, I will represent to you, this document is a consolidated list of all of the referral comments, the 4 rounds of referral comments that went back and forth between county staff and public service. And again, does this look familiar to you, or do you have any reason to dispute that this is a consolidated list of referral comments and the company's responses?
I don't have any reason to dispute it.
Okay. And so just to provide a little context, like if we could jump to maybe page 40. And here, for instance, in the last box on the lower left, one of the comments here indicates the emergency response. I assume it means emergency response. The ER plan provided is too general and not specific for rural districts. I don't need to read everything. And then in the response line, this is from public service explaining kind of its position and its response to that comment. So does this appear to you as kind of what you would expect to be the back and forth that you refer to in your testimony as part of that referral comment process?
Yes.
Okay. And then if we could scroll down to page 79. And this is part of the 3rd set of referral comments that public service responded to. And let's see. And if you see, let's see, by my count, it's the 3rd box, but it's the 2nd comment box. Site-specific plans are required per the LDC. And here, public service says Xcel Energy has prepared a wildfire mitigation plan specific to El Paso County, which is submitted concurrently with this response document. And so do you have any reason to dispute that is part of this referral comment process through this 3rd round of referral comments? This was the point in time that public service prepared a site-specific El Paso wildfire mitigation plan.
I think that there was some discussion at the hearing about that plan, and I believe it was Ms. Chester that said that there may have been a problem with submitting it, but other than that, I assume this would go along the normal course of the process.
Okay, I think we can take this document down, and what I'd like to do is pull, well, I don't know that we need to pull that document up, but let's turn to the company's final application, which I believe the company submitted in July 2025. Does that sound about right?
I wouldn't know the specific dates of the
Okay.
that happens before the hearing. I just know when the hearing is scheduled generally.
Okay, and so the company, the final hearing was on July 24th, 2025, right?
That sounds right.
Okay, and so going into that hearing on July 24th, you were presented with the company's final application, is that right?
Yes.
Okay, and are you aware that that final application, I think it's come up, it's been pulled up on the screen a couple times, we'll probably open it up sooner or later, but that it was about 2,000 pages long?
It was substantial.
Yes, about twice as long as the initial application that the company had filed, right?
I don't remember the exact numbers, but that sounds reasonable.
Okay, and so the company's final application submitted in going into the hearing on July 24th, 2025, that was filed some 4 years after the company initially began interacting with county staff. Does that sound right?
I don't recall the specific dates, but I do know that it was sometime.
Okay. If we could go back to Chair Geithner's testimony, hearing exhibit 203 at page 18. And I'll cut to the chase. Part of why I'm really interested in walking through this detailed background and this multi-year process is because you have reached the conclusion in your testimony that the company, your interpretation was that the company had settled on its proposal before the permitting process began, and that the company just wanted the board to rubber stamp its application. I'm having a really hard time reconciling those conclusions and that testimony with the back and forth process that we just went through and that you've acknowledged occurred. So I just want to make sure first, I'll jump to the question. Is it still your testimony that after 4 years of company engagement, all those public houses, the 4,000-mile siting study, county staff working to help push the line further east, is it your testimony and your position that the company had settled on its proposed route before the permitting process began?
It is.
Okay. And next, again, is it still your testimony today that after those 4 years of county meetings, after a 2-year siting process, studying more than 4,000 square miles of study areas for segment 5, 4 rounds of referral comments, a 500-page staff report, that it was the company's expectation that they just wanted the board to rubber stamp the application?
Yes, the process that is being described does not override the criteria that is in front of commissioners that we are legally bound to make our decision off of. And I stand by that they did not try to satisfy that criteria that was placed before us, even after in-depth questioning to try to get to those answers.
Okay, and to be clear, you reached these conclusions after 4 years of engagement between county staff and the company that you had no role or no part in?
I evaluated the information that was put before me in the hearing as is required by law with the criteria that is set forward that commissioners are bound to use to evaluate the application, regardless of things that happen or what the process is prior to.
Okay, understood. And then just to clarify, though, that was information that I think what you're testifying to, you received as part of the July 24th, 2025 hearing. That is not based on any personal information that you had in the 4 years leading up to that hearing.
Correct. Again, that responsibility of commissioners is to evaluate against that criteria the information that's provided in the hearing.
Understood. I'd like to change gears just a little bit. Chair Geithner, if we could pull up, I believe this is, let's see, hearing exhibit 102, attachment JLC 10. While we're pulling this up, this is the resolution, the board's resolution denying the permit. And so I think in your testimony, you indicated that the basis for denial, or for your decision to deny the permit, was based on a combination of things. And I think you also testified that the reason for your vote is captured in the board's resolution. Is that right? I can pull up your testimony if you'd like me to, but try to avoid pulling up another document if we could.
Yeah, I'd prefer to see the testimony just to ensure.
Sure. So if we could go to hearing exhibit 203 again. at page 10, line 21. Sorry, and I think I'm looking up. We did not see the information we thought the issue deserved. It was a cumulative thing. And then if we could also jump to page 15. And let's scroll down just a little bit. Here we go. The basis for my vote was consideration of the legal criteria and is captured in the board's resolution.
Yes.
Okay, so I think what I've interpreted from your testimony is that your vote to deny it was based on a number of factors. It wasn't just any one thing, right?
Agree. It was a lack of satisfaction of a great deal of our criteria.
Okay, and then I think what you're saying here in your testimony is that the basis for your vote, you're saying the resolution captures the basis for your vote. Is that right?
Yes.
Okay, so if we could pull up the resolution.
That was that JLC 10, right?
Oh, yep, yep, exactly, JLC 10. And if we could scroll down, what I'm trying to do is really kind of distill a couple of the key bases for denial, like where you have indicated that it was a cumulative set of several reasons. And so at the top of page 2 here, I see one basis, failure to describe and evaluate underground options. Is that right?
I'm sorry, the screen's a bit far, so give me a moment to get a little closer. It's difficult getting old.
No worries.
I do see that, yes.
Okay. And I'll just be honest, I'm kind of a list person. So that's why I'm wanting to go through this, is to distill. Number 1, failure to evaluate underground options. Number 2, jumping right down below that, inadequate evaluation and mitigation of wildfire concerns.
Yes.
Number 3, concerns with the master plan. And I think the resolution itself says based on potential to contribute to urban sprawl or leapfrog development.
Yes.
Next, adverse effect on local governments to provide local infrastructure and services, particularly emergency services.
Scroll down.
And I think we can scroll down
Yeah.
if you need to. And that would be number 4 here in this list. That the numbering's a little different than what I've been going through, because the first 2, the numbers repeated themselves.
Yes, ma'am, I see that.
Okay. And then the last one on this page, visual quality, view sheds.
Yes, ma'am.
So if we go through that, is it fair to say, if you were to come up with a bullet point list, and again, I understand that the resolution summarizes your position, but undergrounding, wildfire, urban sprawl, leapfrog development, inability of local governments to provide emergency services, and then scenic view sheds and vistas. Does that sound like a reasonably accurate short list of the key concerns that you've identified in the resolution?
Yes, I would say reasonably accurate. I would say there were additional concerns brought up through the hearing as well. And I would also say undergrounding was not a concern that was brought up by me specifically. It was a colleague.
Oh, okay. So that's helpful. And just to be clear, this resolution, the commissioners issued this resolution denying the application after the July 24th hearing. Is that correct?
Correct.
Okay. So let's turn, we've had a lot of discussion on wildfire, so we'll talk a little bit more about wildfire. Now, I think in your testimony, you stated it was your view that the company appeared to minimize wildfire concerns. The company did not take wildfires seriously, and that this was a big factor in your vote. Does that sound like your testimony? And we can pull up, again, that's hearing exhibit 203 at page 11 and page 16. At page 11, line 22, I believe. And so I just want to confirm, it's your position and your interpretation that the company largely minimized the issue of wildfire mitigation. And that was one of the bases for your denial.
Yes, ma'am.
Okay. And then if we could jump to page 16. I think we're looking at lines 5 through 7. And I think you articulate that the line 6 through 7, the company did not take this issue seriously being wildfire, in my view. This was a big factor in my vote. So is it fair to say that that concerns with wildfire and wildfire risk, that was kind of one of the largest factors in contributing to your vote to deny the application?
I would say that it was the wildfire concern as well
Okay.
as how that relates to the overwhelming of emergency services in this specific situation where there are volunteer fire departments only.
Okay. And when you reviewed the company's 1041 final permit application that had been submitted before the July 24th hearing, had you reviewed the company's El Paso specific wildfire mitigation plan?
I believe that was part of our backup materials that I did review.
Okay. And so just to be clear, you do not dispute that the company filed that wildfire, the El Paso County wildfire specific plan, correct?
I believe that was in the package that we received, yes.
Okay. And so when you say that that wildfire concerns were a big factor in your vote, had the company filed an El Paso specific wildfire mitigation plan that did satisfy your concerns, do you think your vote would have changed?
I assume that you are, I'm going to ask you to repeat the question for me to make sure I understand what you're asking, please.
Yeah, so I guess when you say that the wildfire concerns were a big factor in your vote, what I'm trying to understand is, had the company filed a sufficient wildfire mitigation plan, in your view, would that have been a big enough factor that it would have changed your vote?
Would have been a step toward changing my vote, but as I've mentioned, we have a set of criteria that we weighed against that I specifically talked about each one of those ways I did not think it met. So this was one area. And so it certainly was a piece of that. But again, you know, in order for any applicant to receive a vote of yes, they do need to meet the criteria that is laid out. So I can't say, I would say they would need to meet all of the criteria as laid out, not just necessarily one piece.
Okay, so other factors in all likelihood probably still would have led you, and if nothing else changed, those other factors probably still would have led you to deny the application.
Mr. Chair, calls for speculation.
If you could rephrase, Ms. Shields, that'd be great.
I'm happy to move on. Am I correct? Are you aware that El Paso County has a community wildfire protection plan?
We have lots of emergency management plans, yeah.
Why don't we pull up, we have a document pre-marked as hearing exhibit 121 in box.com. Okay. Does this document look familiar to you? And to be open, I don't have a lot of substantive questions about this document, so we could perhaps do a quick scroll through it. I'm just mostly looking to see if you're familiar with this document, if you've seen it.
I am certain at some point over the 5 years and the thousands and thousands of pages, I have seen this. But I don't recall it. We review a lot of materials.
Yes, understood. And so what I'm curious about, I pulled this document from online. It looks like it's El Paso County's Community Wildfire Protection Plan. It's from 2011. And so what I'd like to confirm with you is, are you aware of any more recent plans that the county has developed or has in place since 2011?
So I think we're talking about the specific title of documents. As I said, we have a lot of emergency management planning. We have entered into a regional emergency management office. And so again, I can't speak to the exact titles. I know that there is ongoing planning regarding all emergencies, including fire in El Paso County. I can't speak to the specific document names.
Okay, no, that's fine. We can take this down. I do not plan to move this into the evidentiary record. But to your knowledge, the county, Chair Geithner, does not have a more recent or more updated community wildfire management plan than the 2011 plan that we were just looking at.
I would not concede that because again, we're talking about the name of one document and we may have renamed, moved into different areas. We have certainly done considerable planning. I mean, just recently, I can say we've added AI protections and looking at modeling for evacuations and different things. So we are constantly working on wildfire planning. So I think the name of that particular document or what it is, that's all inconsequential to the overall reality that we are always planning for wildfire.
Okay, and you're not aware though of a comprehensive, similarly named document that has been updated since 2011?
I just couldn't speak to that specifically.
Okay. Now if we could pull, let's see. Let's pull up hearing exhibit 102, attachment JLC 5, revision 1. And this is a large document. But I think we've already pulled it up. Hopefully it's in a tab.
Yeah, your last one kind of crashed me for a second. So give me a second.
And
JLC
so I was worried that it might crash you. So if you could indulge me, I actually have the one page. I only have one page I want to look at on that, and I plan to look at it a few times. That we've pre-marked as hearing exhibit 110 on box.com, and hopefully that avoids crashing your system.
It actually crashed box. That's what I meant. So just give me a second. I have the JLC 5 open still, just not box. So what page is it in J? Just give me a second. Exhibit 1.
Exhibit 102, JLC 5, revision 1.
Yeah, I have that. Which page?
Okay, page 2114.
Oh, I've got it still up. Thanks.
All right. And Chair Geithner, so to provide a little context, this is a map of El Paso County, eastern El Paso County. Does this document look familiar to you with the yellow line? And we can scroll down if you'd like to see the legend.
It looks like something similar. I've seen many, many maps.
Yes.
But yes, it looks like something that is similar to what I've seen.
Okay, understood. And so this is from the company's 1041 final permit application. And this is a map of where the proposed route of segment 5 would run through El Paso County. And you see down in the legend, the yellow line represents the proposed transmission route. And so if you need a moment to orient yourself or want to scroll, need to scroll up or down just a little bit to orient yourself with this map. I assume the roads look familiar to you and that the map generally looks familiar to you. And if we could, and actually while we're down here on the legend, you see down in the legend, there are some existing transmission lines up in this area. The purple represents a 69 kV, the green 115 kV transmission lines, the blue, a large 230 kV, and then the red 345 kV. So if we could scroll up. So Chair Geithner, you're aware where the company has proposed to site the pathway project, segment 5, the yellow line. There is already some existing transmission infrastructure up in that area, right?
I would say it appears from the map and from my general understanding of the area, yes.
Okay. And would you agree that the blue line, the green lines, the purple line, and the red line, those transmission assets pose some level of wildfire risk within this area of eastern El Paso County?
I don't know anything about those transmission lines to speak to this specifically.
Okay. So you're not willing to agree whether or not those lines present any heightened wildfire risk?
Again, I think I don't know anything about the specifics of those lines, so I wouldn't want to speak to that.
Okay, but it is your conclusion that this yellow line presents heightened wildfire risk?
It is my conclusion that the applicant did not satisfy the criteria to ensure that our emergency services were not overwhelmed.
Okay. Is it your understanding that existing emergency services are equipped to handle potential emergencies on the existing transmission infrastructure in this area?
I haven't evaluated that because it did not come in front of me at a hearing.
Okay. Are you aware whether any of the existing transmission owners or operators have guaranteed to the county that their assets will not cause a wildfire?
Again, my role in evaluating these types of projects comes at the hearing portion. Those are the only times that evaluation has been in front of me. So I can't speak to any of the other items or what would have happened or could have happened in the past.
Okay. And again, based on only the information that you saw during that hearing on July 24th, you were not satisfied that wildfire risk had been sufficiently mitigated for the yellow line.
I would say in addition to the fact that there was an interplay with the risk and the potential for overwhelming emergency services in that area, that would be correct.
Okay. Are you aware that Public Service Company of Colorado has a commission-approved wildfire mitigation plan?
I believe that was stated in the hearing.
Right. And I think when you went to the hearing, the commission had orally approved that plan, correct?
That is my recollection of what was stated in the hearing, yes.
Okay.
I'm sorry, can you repeat that? There was some background. And if you could mute yourselves, county council, please.
So I think where we had just gone, are you aware that the company has a commission-approved wildfire mitigation plan?
Again, I believe that was stated in the hearing by one of the individuals there to represent the applicant.
Okay. Are you aware that the total estimated cost of that plan is about $2 billion?
I don't believe that was discussed at the hearing that I can recall.
Okay, so going into that hearing, had you reviewed the company's proposed wildfire mitigation plan that had been orally deliberated on by this commission?
I do believe that was included in the backup materials, and I reviewed those, yes.
Okay, and since that July 24th hearing, have you reviewed the company's 2025 to 2027 $2 billion wildfire mitigation plan?
I have not reviewed it extensively. I have looked at the document, but not to a great, not to an extensive way.
Okay. And are you aware that the company's wildfire mitigation plan covers assets located in any company-owned asset throughout the state of Colorado?
Again, I'm not familiar with the details of it. I couldn't recall the details of that today.
Okay. Now, are you aware that this yellow segment 5 that we're looking at on the screen throughout El Paso County, are you aware that this traverses tier 1 wildfire risk areas with it is set by the company's commission approved wildfire mitigation plan?
I do believe that was presented in the hearing and in the materials.
Okay. And in fact, it passes through and are you aware tier 1 is the lowest level risk within the company's wildfire risk map?
I could surmise that because it is the number 1, yes.
And as you've also indicated, your own staff was involved or has represented that they worked with the company to push to a route that was further east in El Paso County in this particular area. You've heard that, right? And you don't dispute that.
I've heard that, and then I have stated that I don't have any knowledge of those specific conversations.
Am I right? The county did not conduct an independent wildfire risk analysis specific to Eastern El Paso County or where the segment 5 was going to run, correct?
I don't believe that was the case, though I do believe we did get or ask for a response from local fire.
So you asked for a response, but just to clarify, the county has run no independent risk analysis associated with the proposed segment 5, correct?
Not that I'm aware of.
Okay. Are you aware that the company actively owns and operates transmission infrastructure throughout much higher risk areas throughout tier 1, tier 2, and tier 3 areas across the entire state of Colorado?
I'm not intimately familiar with the infrastructure, but I could reasonably understand that to be the case, yes.
Okay. Now I'd like to turn a little bit. If we could go to hearing exhibit 203, this is your testimony at page 16. And while we're pulling that up, I think that there appears to be a little confusion in the record. What strikes me as confusion, so I want to make sure that we're all aligned. We have a clear record. At lines 2 to 3, I'm sorry, at line 2, you indicate that the county staff, repeatedly asked for a site-specific wildfire plan to no avail. And so what I'd like to confirm is, based on the events that have unfolded, based on the various iterations of corrected testimony that the county has submitted, is it still your position that staff repeatedly asked for a site-specific wildfire plan and the company never provided one?
I believe there's some confusion around this. My
Yeah.
recollection from the hearing was that there was back and forth about this. I think I mentioned this earlier, that the applicant said that they believed that they had submitted everything and that maybe it had not been transferred properly. I would say that led me to believe that not all of the documentation that they intended to had come through properly. So I believe that there's a bit of confusion here. I think it would be hard for me to assume that everything that I received was everything that they submitted. So I just trying to be as straightforward here as possible. I know that there was some discussion about that in the hearing, and I can't speak for what they intended. I can just tell you what I heard from staff and the applicant at that hearing.
Okay, and so I guess part of what I'm just trying to explore is if any correction or clarification to your testimony is warranted here because of that confusion that you have appropriately pointed out. So based on your understanding, as of when you went into that July 24th hearing, were you aware of and had you reviewed an El Paso County specific wildfire plan that the company filed?
I know that there were some materials that referenced El Paso County specifically. Again, my understanding though is that they were not deemed to be sufficient to what was being looked for, meaning they were deficient in addressing all of the items that the county believed that needed to be, or staff believed needed.
Okay, and so I'll represent to you. Yesterday, we uploaded and moved into the record a screenshot from the EDARP system reflecting that I believe it was on May 7th, an El Paso County wildfire mitigation plan was submitted. And so I just, again, want to make sure that you're not questioning whether or not that plan was actually, that the company actually submitted that plan.
Again, I think I want to be careful here because you can put the title on the top of a document and call it something, but it's, I think, a matter of did it actually meet the requirements? And I think that may be where the confusion is from my perspective, from what I heard between staff and the applicant at the hearing.
Okay.
I do believe that there were pages that were represented as such.
Okay, so yeah, so we're not you are not disputing that something was filed with that title on it. Okay, understood. And so again, that document, it was the county specific wildfire mitigation plan, which I'll represent to you, is over 200 pages. Do you recall reviewing that document prior to the July 24th hearing?
I do recall seeing those documents and reviewing the packet, which that was a part of the packet, but I don't recall the specifics at this moment.
Okay, so you don't recall the specifics, but nonetheless, your concerns with the adequacy of the company's wildfire mitigation planning was a big factor in your decision to deny the permit, right?
Yes, as I said, the planning but that is very closely related to the concern over overwhelming the emergency services.
Okay. And if we could go back to hearing exhibit 102, attachment JLC 10, you are not aware of a checklist in the county code setting forth what needs to be included in a wildfire mitigation plan to support a 1041 permit, correct?
Off the top of my head, again, you're getting very down into staff level details that are usually handled by staff.
Okay. But you are not aware of in the ordinance or anywhere in the county code, anything setting forth a checklist that needs to be included in a project specific wildfire mitigation plan?
Again, you're getting down into details that we don't spend a lot of time into what the staff does to get those ready. I can tell you what we evaluate on is that criteria, and that criteria is provided to the applicant, and it is clear to them that they must satisfy that. That's what the commissioners will be using to make their decision.
Okay, and so let's say another applicant were to come forward to the county who wanted to seek a 1041 permit for a transmission line in eastern Colorado. Based on what is here in this ordinance, do you think they would reasonably know what they need to include in a site-specific wildfire mitigation plan?
And so when you are saying ordinance, what are you referring to?
I'm sorry, when I meant resolution.
I think that the information is presented, but I think that it is also important to remember that we've talked about the consistent back and forth that happens between staff. And I think you mentioned that there was considerable amount of that. We encourage all applicants, you know, again, this is general, these are really down to the staff level questions, but we encourage all applicants generally to make sure that they understand the process. That's why that back and forth exists, to get plenty of opportunity to do so. And so I would say, I do believe that the process is sufficient to provide every opportunity for an applicant to understand and attempt to meet that criteria. We have people do it all the time.
Okay. And are you aware, so yesterday, Ms. Parsons testified that her report indicated a presumption.
Oh, counsel, I apologize. Are you able to hear us now?
Yes.
Yes.
Okay, my sincerest apologies. Counsel was attempting to raise an objection, but I think our microphone was muted. I'm very sorry about that.
On this question or a prior one?
We can proceed, Mr. Chair.
Okay.
Thank you. Okay. Yesterday, Ms. Parsons testified that her report indicated a presumption that the 1041 permit would be approved. Did you hear that testimony?
I did not.
You did not? Okay. Let's turn to, I'd like to talk a little bit about emergency services. And if we could go back to that, Exhibit 102, JLC 5, Revision 1 at page 2014. It's that map of where the proposed line will be.
And just so you know, I obviously can't have the whole thing on my screen and it be very visible. So if you need me to move around, just let me know.
Thank you. And so I think this is just for visual context. So walking through one of the next concerns in the ordinance that form the basis for your recommendation to deny the permit, you were concerned about adverse impacts to the county's ability to provide emergency services. Is that right?
I think emergency services in the area. Yes.
Emergency services in the area. Okay. And so, would you agree that for the existing transmission infrastructure that's located in this area, the green line, the blue line, the purple line, and the red line, that those transmission facilities would very likely rely on the exact same emergency service and medical facility providers as the proposed pathway project?
Without seeing the fire department, and we have many fire protection districts, I wouldn't be certain of that.
Okay. And so my understanding is that the El Paso County Sheriff's Office has a wildfire response team. And that is one of the teams that the county has indicated may be responsive in the event of a wildfire. Is that right?
It's a bit more complicated, nuanced than that. Yes, the sheriff's office does have that, but there are fire protection districts throughout the county, and who has the authority and response on a fire is guided by those things as well. So we do work all together as a team, but there are quite a few different districts that could be impacted.
Okay, and so just to confirm that same or similar universe of emergency responders would be implicated if there were a fire that occurred on the blue transmission line here, or one of the green transmission lines, or one of the other existing lines, correct?
I wouldn't say that's correct. As I stated, we have multiple different fire districts. And so, I mean, that's a very long blue line. I can see a little bit near the Peyton area. That's a different fire district. So there are different resources. It would have to be evaluated on a case-by-case basis.
Has the county conducted an analysis of the potential costs associated with emergency services that would be needed, that could be needed to support the yellow segment 5 line?
I'm not aware of that. That would normally be the applicant's responsibility, again, to prove that criteria. So they would need to bring to us an assurance that the emergency services were acceptable in that area.
Okay, so it's your position that it was public services responsibility to quantify the potential cost of providing emergency services in this area?
No, that's not what I said. I said that the criteria requires us to evaluate whether or not the emergency services are sufficient. So it would have been the applicant's responsibility to demonstrate to us that case. In fact, that came up in the hearing. We asked if they had had conversations and looked at working with those volunteer fire departments about providing any help that they might need to be able to meet those services. And they indicated that they had not. They did say that they might in the future, that they had in other circumstances, but they did not commit to anything to help the emergency services in that area.
Okay, and I think what I'm trying to get at here, though, is that the resolution, one of the bases for denial is changes caused by the project in the cost of providing emergency services or other governmental services or facilities. And so what I'm trying to get at, the county has not gone through any type of analysis to quantify what the potential cost might be associated with providing emergency services or other governmental services.
I don't think that we need to do an extensive cost analysis to determine that a volunteer fire department would be woefully insufficient.
Okay, and just to clarify though, the county does not have an impact fee and has not chosen to seek an impact fee associated with segment 5. Is that right?
Off the top of my head, I'm not aware of a program that is in motion, and I'm sure, as you know, our codes don't change midstream, so to speak. We evaluate what we have based on what's in front of us at that hearing.
Okay. And so you would agree, wouldn't you, that if there were incremental cost associated with providing emergency services on this stretch of line, that an impact fee could be one way that the county could reasonably recoup some of those costs, right?
Well, I think you're conflating multiple things here. It's not the county that provides that service there.
But the county is the entity that issues a approval or denial of a 1041 permit, right?
I mean, obviously, yes, that's why we're here today.
Okay. And so what I'm trying to understand again is that the resolution says changes caused by the project and the cost of providing emergency services or other governmental services. And so if cost of emergency services was one of your stated concerns for denying it, couldn't you have imposed a fee structure to recoup those costs?
I think that's really speculative, and again, very legal. We'd have to get into the what we can tax. I believe fire districts may be able to impose an impact fee, but again, that wasn't what was before me at the time, was to decide on an impact fee. So, you know, again, yes, there are cost concerns. We talked about that at the hearing. We asked if they had been willing to talk to the fire department and provide any of those things, and as I said, there was no commitment to do so at that time.
Okay, I think so. I'd like to pivot a little bit, and I think we can actually keep this document up and talk a little bit about the master plan. As the Board of County Commissioners Chair, you're familiar with the county's master plan, is that right?
I'm reasonably familiar with that very large document, yes.
Okay, and is it your understanding that the master plan, that's a guiding document, it's not an ordinance, for instance, right?
Yes, I'd agree with that.
Okay. And so in the resolution, one of the reasons that is indicated that the board denied the permit is the potential of promoting leapfrog development, inconsistency with the existing rural nature of the land, and impact to view sheds. Right? That sounds familiar?
Yes.
Okay. So again, looking here at this document, is it your position that the line should not be built in eastern El Paso County? Would you prefer to see the line move west toward population centers?
I wouldn't want to speculate on that. Again, when we review these, we compare it to a set of legal criteria. I would have to understand all of the information as would be presented to make any of those decisions. And I take that very seriously. So I would not speculate about how it would or would not meet those things. An application would have to come before us.
Okay. Is it your position that the existing transmission infrastructure in this area does not promote leapfrog development?
Again, I think this is what's existing there. I can't speak to that. I can only speak to the criteria that was in front of me, the questions that were asked of me in relationship to that criteria. I can't explain what things happened in the past or what the reasoning was. I just can't answer those questions.
Is there a particular growth center or a community or growth center area on this map that you are concerned could potentially expand because of segment 5 being built?
Are we still looking at the transmission map? Is that what you're referring to?
Yes.
If there's a particular growth center, can you repeat
Yeah,
that?
I'm just concerned, like the resolution says there are concerns that segment 5 could encourage leapfrog development. And
Yes.
so what I'm worried about in looking at this map, I'm trying to figure out where you're concerned leapfrog development might happen or where a growth center could expand because of the transmission line.
I think, as the resolution states, that it's near the transmission line. Sorry, I'm not tracking what you're trying to ask.
I'm not tracking how this line will contribute to leapfrog development. And so I guess what I'm interested in exploring is how you're concerned this segment 5 is going to contribute to leapfrog development.
Okay, I think I understand now. I'm going to try and answer that. Sorry about that. I was just trying to understand the question.
Understood.
So there was discussion as well about associated development, which is also part of the criteria. So it's this line and associated development. And so I think that the applicant mentioned that there would be also considerable other development that would be coming as a result of this line. And so that was a piece of the consideration for that leapfrog development as well, is that it would bring considerable, and I think in the words of the applicant, roughly, I'm not quoting him here, but that it would bring considerable other development to the area.
Okay, when you say considerable other development, do you mean generation projects, like solar projects?
Yes.
Okay. And so your concern is that by citing this by citing this line here, it's going to bring a bunch of solar projects to eastern El Paso County.
I wouldn't say solar projects. No, I'm not opposed to solar projects specifically. It's just the idea of it taking up a lot of this land and again, leapfrogging into areas where we could have additional development that this area is not sufficient for. As well as I think our master plan speaks specifically about how important our ag lands are. And so there was consideration about that as well.
Okay, are you aware that the company has full site control of 100% of the land rights in this area of El Paso County for the line?
I guess I'm not sure what you're referring to.
Are you aware that Public Service Company of Colorado has secured 100% of land rights needed to construct segment 5 in El Paso County?
I am not familiar with any of their land holdings specifically.
Okay. And the type of generation projects that you were referring to, wouldn't you agree that any new project that sought to interconnect to this line would need to go through its own 1041 permitting process?
I'm not going to speculate for sure, but there's a possibility, yes.
Okay. But as part of this 1041 permit application, Public Service is not seeking approval to cite any generation projects in this area. Public Service is only seeking to cite a transmission line, correct?
I'm going to refer back to the criteria that we were using to make the decision, that it specifically talked about associated development. So that was the decision that was made based on the criteria that was in front of us and that the applicant was fully aware of.
Okay. So any new generation project, though, that's not included in this 1041 application would be subject to local county permitting requirements through a separate process, right?
Again, I'm not gonna, without seeing an application, I couldn't speculate for certain what could be or could not be.
Okay. Last area I would like to turn to, and I am going to skip over undergrounding only because you acknowledged that that was not a particular concern that you had with this particular application, right?
Correct.
Okay. So the resolution indicates that the project is not reasonably necessary to meet projected needs or regulatory requirements. Is that correct?
Yes, for our area specifically, which is what we evaluate here.
Okay, and are you aware that this commission has already approved the public pathway project through a certificate of public convenience and necessity?
I believe that was mentioned at the hearing.
Okay. El Paso County did not intervene in that proceeding, did it?
I am not aware of that, and I am not very knowledgeable of what that would even look like, if I'm being very honest.
Okay, so if I were to represent you, El Paso County did not intervene in that proceeding, you would have no reason to contest that, right?
I just don't have any knowledge of that. So I
Okay.
don't have any knowledge
And
of it.
so if you have no knowledge of that, I assume you did not read the commission's decision granting a CPCN for the pathway project. Is that right?
Not that I recall, no.
Okay. And so in voting to deny the 1041 permit, you did not take into account this commission's finding of public need and public convenience for the pathway project.
It would have been improper for me to do so because it's not part of our criteria. As I said, our criteria is specific to serving the area. And so again, my legal responsibility is that criteria.
Okay. Would you acknowledge that by denying the company's 1041 permit, that El Paso County may be frustrating the state's objectives that led to the PUC to issue a CPCN for the Pathway project?
Calls for a legal conclusion, Mr. Chair.
You could rephrase, Ms. Shields.
Yes, so by not taking into account this commission's decision finding the Pathway project as necessary, do you acknowledge that El Paso County may be frustrating the state's needs for the Pathway project transmission line?
No, I would acknowledge that I'm following the law and applying the application to the criteria that I'm legally bound to apply. That's what I would acknowledge.
Okay. Along those lines, if this commission today were to issue an order granting the company's application, would you anticipate that you would recommend that the county would appeal that decision?
Mr. Chair, speculation calls for a legal conclusion, relevance.
I'm not asking for a legal conclusion. I will be clear. I'm asking Chair Geithner if her recommendation would be that the county appeal the decision. I'm not asking for a legal recommendation. I'm asking for her position as the chair of the El Paso County Board of County Commissioners. If this commission grants the company's application, would she recommend the county appeal?
Not made a recommendation, council.
Say again, Mr. Martin.
This commission has not made a recommendation, whatever the question might imply. It calls for speculation about a decision that will be made in the future.
I'm going to overrule the objection, but Ms. Chair Geithner can answer any way she feels fit.
I'd say, first of all, I don't make decisions for this board. And second of all, we make very thoughtful decisions here in El Paso County, generally speaking. And so all I can say is that we would have to evaluate all of the options available and make a decision, but I don't have a predetermined decision at this time.
Thank you. I have no further questions.
Let's see. Commissioner Plant, questions for Ms. Geithner.
Thank you, Mr. Chairman, and good morning, Madam Chair.
Good morning.
I just had one clarifying question, and I think Ms. Shields kind of hit on this a little bit, but unfortunately it didn't help me to understand any better. So I just wanted to see if you could clarify this for me. And I know you can't speak for the whole commission, but just how you, as a member of the commission, think about the term leapfrog development. I've heard this term used in the past to sort of reference residential development, and a concern is usually around cost for extending fire, police, water, sewer, et cetera, to serve that type of development, but I haven't heard it used in this context. So I was just wondering, what are the types of developments that to you would constitute leapfrog developments, and what are the concerns that are related to your consideration of that term?
Sure. I think it's any kind of development that could strain the resources that we have in the area. As I'm sure you're very familiar with, rural areas have very limited resources in terms of any kind of infrastructure and emergency services, those things. So it's really, to me, anything that could add potential strain in an area that is just not really ready to receive that type of growth yet. It's why we try to have growth happen in a kind of progressive way, connected to the growth that's already existing, so that those services and infrastructure and all those things kind of move with the growth, rather than jumping out into a large rural area that we may all of a sudden have to deal with, anything from traffic to those emergency services. I hope that helps.
Yeah, I'm just trying to figure out, I mean, one of the sort of the one thing that you've highlighted here is a concern around, a large solar development. But I mean, I'm not sure what kinds of services would be associated with that. If it's just sitting out there somewhere, it's not, conducting business or bringing in traffic or things like that. I'm trying to figure out what the concern is around that specifically that raises a concern for the county.
Yeah, and as a reminder, I didn't say that it was just solely the solar project. Actually, in the hearing, there was mention of multiple projects that could be all types. So it wasn't just specific to a solar project. So I think the idea of having a lot of different projects was presented, and that was part of the concern as well. Difficult to predict all of the pieces of that. And so I couldn't speak to everything and just say it clearly could present a problem of depending on what all of those additional developments would be, but it was stated that there would be additional developments.
Okay, thank you, Madam Chair and Mr. Chairman. I don't have any other questions.
Thank you, Commissioner Plant. Commissioner Goman.
Yeah, good morning, Chair Geithner.
Morning.
Just a few questions for me. Curious if, in your view, there are or were conditions the county could have imposed to address your specific concerns with the application.
I don't know that the deficits were pretty large. It wasn't one piece of criteria. It was, I think I would say the majority of our criteria that was not met. And so I don't know that there could have been conditions discussed at that meeting that would have met all of those at that time. But again, we did try to get towards some of those with asking about different pieces. The applicant did not seem willing to, I would say, for lack of a better term, come to the table to discuss what those things could be. Frankly, they seem to believe that it was already a predetermined outcome.
Okay. And in your view, what was the most difficult shortcoming, I guess, of the application specifically?
I think the one that we talked about substantially was the concern for wildfire mitigation and emergency services.
Okay. And as I understand it from Ms. Parsons, part of the concern there stemmed from not really hearing back or any referral from 2 of the 3 fire districts as part of the review of the application. Is that something you were aware of?
I was aware of that. I wouldn't say the lack of hearing was the concern. However, I think it's the fact that they're volunteer fire departments is maybe why they didn't have the time or manpower to respond to that response. And if they didn't have the time to respond to something like that, it concerned me that how would they be able to protect the community in the event of a wildfire? And in addition to that, I would say the refusal for the applicant to make an agreement with us on trying to determine some of those mitigation things, particularly around the cameras. And when we tried to ask them about and try to get them to commit to helping to make sure that cameras could be in place that would do the detection. Even with the detection, there's a grave concern. If you don't have people to send out to a fire, that's problematic. But those 2 things were substantial that we tried to get them to work with us on. And like I said, they were, I would say, evasive on trying to nail down, making sure that those cameras would be in place if necessary. And as I said, we asked specifically, have you talked to the fire departments about what their needs would be to serve this? And again, there just did not seem to be, they did not want to make any commitments to do those things.
Okay, did the county have specific commitments they were looking for with regard to a number of cameras or locations of cameras that the county determined were necessary?
The commissioners asked specific questions, to my recollection, about could the existing cameras identify a fire on this transmission line? They're quite a distance away. We actually went into specifics, asking about how far they could see and could they guarantee, I asked the question, can you guarantee that it can see this transmission line? And they said no, but that they could evaluate in the future. But again, as I said then, our criteria doesn't allow for, hey, we will if. It's, can you guarantee us that these things are in place? And so we specifically asked if we could guarantee that there would be cameras that could identify any ignition along the line, and we could not get that guarantee. And then again, in addition to that, knowing, okay, great, if we have a camera that can identify this is a good thing, but we can't get to that certainty. But even if we could, now the second part is, who are we going to call out to deal with that? And that's why we asked the questions along the lines of, have you spoken with the fire department? Have you, talked to them about the resources that they need? And again, that was not satisfied either.
Okay, thanks. Those are my only questions. Appreciate it.
Sure.
Thank you, Commissioner Gilman. I'm gonna maybe just ask the same questions from a little bit different perspective. To build out the record in an event the commission wanted to develop a set of conditions that could potentially apply to this transmission line development if it were to move forward, any thoughts about what you'd like to see in those conditions to address your wildfire emergency service and other concerns? I guess, are there any dollar amounts or other things that can be done in your view to help address your concerns?
I wouldn't want to speak to a dollar amount. And again, we're unique. We're not like a municipality that just says, we could do the evaluation and say what we need, because we're not the fire department. So I would want to, in consultation with the fire protection district and those that would be serving that areas, come up with what the resources would be needed to ensure that in the event of some sort of ignition, that those things could be dealt with safely and protect the community. So I just can't give you a specific. I wish that, again, that more of those conversations had taken place with the applicant prior to their coming in, so that they would have presented that. None of us would be here today.
Yeah.
Maybe, perhaps. But so I don't want to speak on behalf, but again, I would need to be satisfied that we just know that the community is protected in the event of those. I've been involved in, other wildfires in the area that are really devastating to the community. So that's really what we're looking for, is for the fire department to be able to have the resources that they need. And then again, that other piece is the detection. So, confirmation that there is no doubt that we would be able to detect something happening, and we would have the resources to be able to protect the community in the event that it did happen.
Any estimate on how long it would take to get a view on that? On conditions, is this like hours, days, weeks?
I am not a fire professional, so I wouldn't want to speak for them. My guess was it would take some time to, have some of those meetings, talk to the folks that are out there, maybe bring the sheriff's office in on that as the fire warden. But again, I just don't want to commit to anything. I'm a person who wants to be I'd like to be as transparent as I can, but I also don't like to over promise something that I really would want to know more information on. I'm a bit cautious on making a commitment that I couldn't guarantee without having input from those folks.
One perhaps dumb follow-up question on leapfrog development. For example, if a solar facility wanted to site a new generating plant in El Paso County, doesn't the owner of that facility need some permitting and other approval from the county? So even if this transmission line were to be built, wouldn't the county still have control over any follow-up energy and other development? I just wasn't clear on this. It seems like the leapfrog development would be under your control. Am I wrong about that?
I hate to speculate on any applications until we know what would be coming in front of us. But as I said, our criteria around this particular project included associated development. And so when we asked the questions about what kind of associated development that there could be, and again, I want to be clear, it's not just solar that they referenced to us, that there were several types of potential development that was mentioned. And so that did give us pause on whether that would create some leapfrog development. So is it possible that that could be dealt with? Maybe, but our criteria forced us to deal with it in that moment and to ask those questions there that couldn't be satisfied.
Yeah, I'm not poking at your prior decision. I'm just asking you going forward. Doesn't the county have control over future development? Wouldn't all that need some form of county permit? So don't you have control over the leapfrog development totally separate from your prior decision?
As I said, I mean, likely there would be some sort of process, but I just can't speculate on exactly what they would be without knowing what the application is. Like I said, it was vague. They just said there would be additional things. I can't say without knowing what all those things are, I can't say exactly what kind of processes would be in place. And I guess maybe that is why I'm hesitant to give a firm answer here is, is it possible that something that they're contemplating, some type of development would be different? I just can't speak to that without knowing that detail yet. I would also say that wasn't, again, because there was so much of the criteria, that was a piece of it, but there was so much criteria that wasn't met. Perhaps we would have, been able to dig in on that deeper or those things, but there was so much criteria that they could not meet or did not meet.
Okay, let me ask you the last question, and let me just ask it this way. If you had a 4,000 acre solar facility, that would have to apply for a county permit, right? And you could deny it or approve it or condition it any way you want. So it seemed like that 4,000 acre solar facility would be entirely at your discretion, the county's discretion. Am I wrong about that?
I do not think you're wrong unless the legislature decides to change their mind.
Don't get us started on the legislature. That's all I got. Mr. Martin, you want a little break, or are you ready for redirect?
I'm ready, Mr. Chair. I don't have a lot of questions, and perhaps we can then get to lunch.
Perfect.
Chair Geithner, can you still hear and see us?
Yes, sir.
Great. One point of clarification that arose during Ms. Shields' cross-examination of you. Do staff make a recommendation to the Board of County Commissioners about approval or denial of permit applications?
No, they generally do not make a recommendation. It is up to the elected body to do those comparisons to the criteria. And so they leave that process to us.
Did the staff make a recommendation in this proceeding?
They did not.
Thank you. I want to get, first of all, to Commissioner Plant's questions about development along the pathway route. Are most of the roads in the area paved in good condition?
This is a very typical rural area where we have many gravel roads. And while we always are working hard to improve our roads, they are, I would say, in a very typical situation for rural roads that they don't receive as much traffic and therefore not as much attention.
So do they meet urban standards or some lower standard?
Yeah, no, they typically are very different than our more urban roads in terms of whether, shoulders, curbs, those type of things. And so again, gravel primarily, that is, much more subject to weather and again, designed for low volume traffic, et cetera.
Great, thank you. Do you remember Ms. Shields' questions to you about the initial application from the company to the county and the final application?
Yes.
Let's take as an example the initial application from the company to the county. When that was uploaded to EDARP in real time, did you review it at that point or some other point?
Yeah, as I indicated, I don't go to EDARP when things are uploaded, so I would not have been looking at that time.
You generally review documents before the staff provides you with a staff report?
Yeah, the only time that I really review those documents is what is included with the packet. And to be clear, I guess I should have specified that. That comes, days to a week before those hearings. And so we get that information just before the hearing.
So a little repetitive here, but when the company uploaded the final application to EDARP, did you go to review it or did you wait until some later time?
Yeah, I only reviewed it later as a part of the, again, preparation for the hearing.
So it wasn't contemporaneous with its filing?
No.
Thank you. You give me just a second. Ms. Shields also asked you a few questions about the referral comments from staff and external agencies to the company and the company's responses. Did you review those when they were uploaded to EDARP?
I would not have reviewed those in the same way. I would not have reviewed those things as they came into EDARP, as I said. I only would have reviewed what was included in our packet. So we don't get involved in that back and forth process, or to your point, look for those documents to be uploaded to EDARP and access those.
Thank you. And another point of clarification, I think we've been through this a couple of times, but the first responders are volunteers or paid, Chair Geithner?
They are volunteers.
Thank you. You have a sense of whether most of them work away from the home?
Yes, I believe most of them work a full-time job to support their families.
Many of them in Colorado Springs?
Yeah, that very well could be the case. There's not much out there that they would be working at locally unless they are working in agriculture.
So for response to a fire, to an emergency, if the first responders are going to be fire districts, they'd have to go from their jobs to a fire station first?
That very well could be the case, yes.
Thank you. Does the county pay for or financially support those fire districts?
We do not.
So they're purely volunteer. Was there much discussion, if any, at the Board of County Commissioners hearing about the precise route that the company had proposed?
Yeah, they presented one specific route, yes.
And did anyone propose an alternative?
No, there was no alternative proposed.
Thank you. I think that's the substance of my redirect, Mr. Chair.
All right. Any
Chair Geithner, thanks for joining us. Thanks for making some time for us. Appreciate it. You can be excused.
Thank you for your time.
Thank you. Ms. Shields.
Yes, we just had two matter. First, we wanted to let everyone know that we plan to waive Chief Stanwood. So we do not have questioning for him. I don't know if the commissioners do.
Commissioner, let's just stick on that for a sec. Commissioner Plant, questions for Chief Stanwood?
I do not.
Commissioner Gellman?
Give me 1 second.
Yeah, take your time.
I have something jotted down, but I want to make sure we already covered it, which is highly possible. 1 second.
Yeah, take your time. Why don't, while Commissioner Gellman's doing that, why don't you go to your second item?
Great. And then I just wanted to represent, we do have Ms. Chester teed up to come on, and I think we just kind of wanted to go through with you your expectations or plan on process. I think that the county may have some cross-examination for staff or CEO who we have waived. And just wanted to confirm, would you anticipate bringing her on after that cross, or you know, and any other procedural notes you have for us on that?
I think Mr. Martin, it'd be my preference to bring Ms. Chester on earlier, just so if there's questions or unresolved issues, we can maybe address it while the record's open. So I guess if it works for you, Mr. Martin, we put on Mr. Stanwood if Commissioner Gellman has questions. And then go back to Ms. Chester and then finish up with CEO and staff. Would that work for you?
We can make that work, Mr. Chair.
Does that work for you, Ms. Shields?
Yes.
Commissioner Gellman, Chief Stanwood.
Yeah, I think my questions have already been sufficiently covered, so I don't need to call him specifically.
I think I'm good with the record on those issues too. So I think Mr. Martin, Chief Stanwood could be excused. And unless anybody has anything else, I think we'll reconvene at 12:30. Ms. Shields, anything else?
I don't think so. We're good.
All right, so we'll reconvene at 12:30 with Ms. Chester. Thanks. Good afternoon. We're back on the record in Public Service Company of Colorado's permit citing in El Paso County, 25A-0355E. Any preliminary matters before we jump into it with Ms. Chester?
Mr. Chair,
Yep.
the county's prepared to waive cross-examination of Mr. Lester and Mr. Bott. We still have a few questions for Mr. Fiedler.
All right. Thank you. Ms. Chester, do you understand you're still under oath?
I do, yes.
Ms. Caliendo, take us away.
Thank you. And for the record, I'm Lauren.
Actually, just 1 second before we go down this path. Commissioner Plant, questions for Mr. Lester or Ms. Bott?
I do not.
Commissioner Gilman, questions for Mr. Lester or Ms. Bott?
I also do not.
Neither do I. So I think Mr. Lester and Ms. Bott can be excused. Mr. Crakes, I suspect that's what you were going to ask.
That is exactly what I was going to ask, Mr. Chairman. Thank you very much. I will let Ms. Bott know.
Thank you. All right. Sorry, Ms. Caliendo.
Yes, for the record, Lauren Caliendo on behalf of Public Service. Thank you, Ms. Chester, for returning to the stand. And Chair, we were planning to do a brief direct to discuss those items that you requested, if that's acceptable.
That'd be great. Mr. Martin, any concerns?
No.
Thank you. Ms. Chester, do you recall a request by the commissioners that the company provide commitments it is willing to make in relation to the commission's approval of the company's application in this proceeding?
Yes, I do.
And did the company prepare that document?
Yes, we have.
If we could please pull up what's been marked as hearing exhibit 122 in our box.com.
There is no 122. There's a 121 again and a 123.
Okay, let me look into that very briefly. One moment. Apologies.
I'll check on my end too to make sure it's not a syncing issue, but so far I don't see it.
If you want to email it to council, perhaps one of us can share our screen.
One more minute.
Yeah, just one moment. We're getting it loaded to box.
What number do you think it was?
122.
And I just checked the web version to make sure it wasn't a syncing. It's not there either.
Okay, it should be in there now. Apologies for that delay.
There we go.
Okay, Ms. Chester, just generally speaking, can you explain the purpose and intent of this document?
Sure, happy to. As stated kind of in the first paragraph there, this document is intended to document the commitments the public service company is willing to agree to, based on kind of all that we had put forward as either benefits or prior commitments regarding the pathway project in El Paso County. And these are a subset really of what was on the document that was brought up on screen, I believe, when Commissioner Gilman was asking me questions yesterday. And so we have taken a look at all of those and have compiled here in this document the set of commitments that we think will allow the project to move forward, be developed in a timely way, and progress segment 5 construction in El Paso County.
Thank you. And before we start discussing more detail, I'd move for admission of hearing exhibit 122.
Why don't we wait till we go through it? I don't, unless, Mr. Martin, have you seen this document before?
Mr. Chair, we saw it over the lunch break. Yes, thank you.
Any objection?
No.
So moved.
All right, so scrolling to the first bullet here, Ms. Chester, can you explain the purpose and intent of that commitment?
Yeah, so the the first bullet, and I'm sure we'll talk about the maybe second and third following, this set of bullets is really describing commitments around our use of El Paso County roads during construction of the pathway project. As noted in this first bullet, we had previously mapped those haul routes and had generally agreed on them with the county, and it amounts to about 121.5 miles. I guess our GIS person was very precise there. So about 120 miles of county roads that we anticipate needing to use for construction of pathway, including hauling and heavy vehicle or equipment. And as previously stated in the benefits and discussion in our application, we recognize that the use of those haul routes may create temporary construction impacts, or we may need to make improvements to those roads in order for them to be utilized for construction. And we are committing in this first bullet to mitigate and repair those impacts and damage, as we move forward with pathway construction, hopefully in El Paso County. And then a commitment to restore the haul routes to their pre-construction condition.
Thank you. If we could scroll down then to look at the bullets below these first three. Ms. Chester, on the bullets here on the screen, can you explain the purpose and intent of these bullets?
Yeah, so this page contains a number of different items related to those commitments. And so starting at the top, we talk about our commitment to restore areas disturbed during construction to pre-construction conditions in coordination with the landowners and current land uses that exist at the time construction starts. El Paso County does have a road impact fee pursuant to a resolution that's listed in the second bullet, and we are indicating we'll pay that fee. We also discuss vegetation management and our commitment to do that in compliance with NERC standards and our commission-approved wildfire mitigation plan. Some additional bullets that talk about revegetation, adhering to best management practices as it relates to erosion and stormwater control, subject to our stormwater management plan. Control of noxious weeds, also in compliance with that stormwater management plan. Further down, there are bullets related to our commitment to continue to coordinate with local fire departments and first responders regarding any of their concerns. Also continuing to offer that online safety training for first responders, and if requested, you'll work with them on any additional training they might need. As mentioned in our hearing with El Paso County in July, we are willing to coordinate with the County Office of Emergency Management to gain them access to the Pano AI cameras that we do have. To date, we haven't had any interest in doing that, but we'll continue to see if there is and provide them with that access. Also a note that the pathway line, once operating, is remotely monitored all day, every day. And the last bullet, I think, rolls to the third page. And our commitment to that we patrol the line at least annually to look for a number of items that are listed towards the bottom there.
Thank you. If we could scroll down just a little bit to see those items. Thank you. And if there's any additional context you want to provide around that item, or we can move on to the additional bullets below.
I think on that item, no additional context. We can continue to go down here. Again, compliance with noise ordinances, state, federal laws, and towards the bottom, I think on this page is a discussion around obtaining other applicable kind of construction related permits that may be required. I know there was a little discussion about that yesterday. And so what we've noted here is that we'll endeavor in good faith to obtain those construction related permits in hopes that the county would work with us and in that same good faith effort to approve those permits. And if that isn't possible, then you know what the result of that would be is that last bullet.
Thank you. And if we could just scroll to the bottom there, I think this last bullet here speaks to what you were just discussing, but just so that everybody can see that there. Ms. Chester, how do these commitments relate to those the company made in its 1041 permit application, including the development agreement?
These are essentially the same commitments that were in our 1041 permit, now just kind of extracted out in this document form.
And just for clarity of record, the company signed that development agreement as part of its 1041 permit application. Is that right?
That's correct. As mentioned previously, El Paso County has a development agreement that would have been approved. I think Ms. Parsons spoke to this morning, would have gone through for approval at the same time of the 1041 permit application. Prior to hearing on the 1041 application, we had provided that development agreement and pre-negotiated it, if you will, because there usually is some back and forth on any agreement. And we had signed that agreement in that form at that time. And that development agreement speaks to a number of these sorts of things. So in that development agreement, we were committing to a lot of the things that are in here, including the road maintenance and repair, which again, we've pulled out and committed to here in this document.
Thank you. And I think Ms. Parsons confirmed this earlier, but if you could also confirm that specific development agreement that the company signed is not in effect, is that right?
That's my understanding is we signed it, although pre-negotiated and agreed to, we signed it, but the county did not approve that as part of the hearing in July for the 1041 permit application.
Thank you. And do you recall a request from the commissioners on further information about an impact fee proposal?
Yes, I did.
And is the company currently evaluating such a proposal?
Yes, we are evaluating impact fee proposal and how we might continue the dialogue on that particular item. Obviously, there wasn't a bullet in this document on that, and what we'd like to do there is in order to address that request from Chair Blank and the commission is to put forth a proposal in our SOP that would, think about some of the concerns or all of the concerns hopefully raised yesterday, the request from the commission to try and solve, that problem or a problem where you've heard from the local community that they have concerns about adequate facilities of certain types, and balance, that with how would such a thing be implemented, not only in the context perhaps of this, but also future work. Because El Paso County, among other counties, are unique in how they choose to implement a fee structure, whether that is called an impact fee, whether that is road, for example, road maintenance agreements or a developer's agreement. I think there's a lot of dialogue to be had about what happens with the equation around that. If we've agreed, for example, to pay for road improvements and mitigation and repair, is that subtracted from an impact fee if that's of a concern? So we want to lay that out in our SOP, because as example, the road repair and maintenance for much of pathway in these rural areas, as noted by the county earlier today, these are typical rural roads. They require a lot of work to support construction, and we do undertake the work necessary. That has been a very large sum of money, sometimes millions in each county that the project undertakes to improve and repair roads. So we want to be thoughtful about how that comes together, and would propose that in the SOP. We also want to think about how that would relate to potential future action on the 3700 filing, and if those things are agreed to, what then happens in the event that appeals are filed, and whether those fees are actually assisting not only the jurisdiction, but also the project in moving forward in a timely way. Additionally, would really welcome being part of additional conversation with a larger group of stakeholders. We obviously have concerns and questions and don't have it all figured out. I think Chair Blank, you mentioned we didn't have the answer yesterday. And my experience around Colorado, working not only in permitting on the pathway jurisdictions, but jurisdictions from north, south, east, west. I, in 1 week, have traveled from Burlington, Colorado to Fruita, working on permitting. So border to border tells me that the communities and the jurisdictions have their own way of doing things, and are very proud of that, and want to make sure we're all kind of working together to hear everyone's goals and concerns and challenges, and figure out how to navigate that from that point forward.
Thank you. And what is the company's proposal for next steps on that issue?
Again, we'd lay out a plan in our SOP or a suggestion, and then see if you were willing to help support CIM or something where that sort of dialogue could be initiated and hopefully continue.
Thank you. One last item for you that came up both yesterday and today. Do you recall questions from the commissioners yesterday regarding public comments filed by the Edison Fire Chief, Mr. Hicks?
I do, yes.
And there was also an exhibit, I believe it was 601 or 602, containing a letter from Mr. Hicks.
That's correct, yes.
And per Commissioner Gilman's requests for the timeline regarding the engagement with Edison County or Edison Fire Chief, has the company since reached out to Mr. Hicks?
We have. I was able to communicate by email with Mr. Hicks yesterday evening after we closed hearing for the day, to provide him my correct contact information, along with Patrick, Mr. Koretich's contact information, and our community resilience manager's information, to let him know that Patrick and I, Mr. Koretich, would be the contacts related to Pathway, and our community resiliency manager would be a broader contact. Mr. Hicks received my email and responded back with information on that he had tried to reach out to us before, understood that one of the folks he reached out to was no longer with the company, and that we may not have been able to respond due to the ongoing litigation or 3700 process. He requested a meeting and provided some additional information in that email about what that meeting would he would hope would accomplish to talk through their requirements for the project.
And was there anything that stood out to you about Mr. Hicks' response to your outreach?
Yes, Mr. Hicks was very interested in meeting, indicated he understood the project had been in public service for a number of years, and didn't want to meet to ask about money. That wasn't his goal. He was just looking to share his requirements for coordination on the project, how to get in touch with them and what to do in the event of an emergency. For example, he said in the communication, first step is call 911, and so on.
Thank you. If we could pull up hearing exhibit 123 out of the company's box. Ms. Chester, is this the correspondence that you were just discussing?
It is, yes.
Excuse me, could you expand that, please, so we can read it more easily? Thank you.
And happy to let El Paso County Council review if needed, but if we could scroll through just to see the full length of the document. If we could pause here on this page to, Ms. Chester, is this the section of the email that you were discussing on your takeaways here?
Yeah, it starts at the top that they had understood that they had reached out to several individuals, received no response from the original point of contact, Delaney. She's no longer with the company, and that the email was sent after denial of the permit, which may explain the lack of response as the legal proceedings were underway. A note about contact from media outlets, and then further kind of the objectives of the meeting that we indicated we'd be willing to have, including worksite safety rules, department capabilities and limitations, pre-planning strategies, and to establish that productive working relationship. And I believe there's more on a subsequent page here as well.
Yeah, if we could scroll to the next page, please. Yeah, and then this top paragraph here, Ms. Chester, is that what you were referring to previously?
Yes. Yeah. I think as indicated by Fire Chief Hicks' email here, the intent of the meeting is to just communicate and coordinate regarding their ability to respond in their fire district. He notes there that he's not looking to present demands for financial contributions, and they're just interested in figuring out how to conduct the work safely, efficiently, and cost effectively. So in response to this outreach, I did follow up with Fire Chief Hicks and presented an option for a meeting date in the next couple of weeks to see if that would work for Fire Chief Hicks. And I think he mentions his deputy chief in here as well. I haven't yet heard back, but assume that I will when they're able to respond, and we'll continue to work towards setting that meeting and having the conversation.
Thank you. And if we could just continue scrolling here, just to look at the rest of the document.
Yeah, this is a second email that was provided by Fire Chief Hicks also yesterday evening, and then an attachment to that document, which I believe was the attachment submitted with his original PUC comment submittal as well. I can't confirm because I couldn't find it on the PUC page, but if we keep scrolling, there was an attachment that provides their initial, what I understand their initial requirements for the pathway project construction, which we would, of course, discuss at a meeting, hopefully to be set up soon.
If we could scroll on just a little bit on this letter. Yeah, thank you. Keep going to the next page. If we could pause here briefly on subsection 2, is this the part of the letter that you took something away from specifically in relation to this proceeding?
Yeah, as noted here, they indicated that any particular fire, whether that be structure fire, which we don't have, but other vehicle equipment or wildland fire, shall be reported to 911. I know there's a lot of discussion yesterday about our wildfire mitigation plan where we indicated we should contact first responders. There was some dialogue about 911 services not existing. But as noted here, there's a suggestion to call 911. Regardless, we'll meet with Edison Fire and determine if 911 is available, and if not, what those appropriate contact mechanisms should be.
Thank you. And if we could just finish our scroll through the document to confirm that this is the remainder here. Thank you. Move for admission of hearing exhibit 123.
Mr. Martin, any objections?
No objection.
So moved.
Thank you. Just one final question for you, Ms. Chester. Does the company intend to coordinate with Mr. Hicks and the other 5 districts going forward?
Absolutely. That is standard for us and required from our construction contractor before beginning construction, to coordinate and have a strong emergency response plan in place for the area they're working in. And we will definitely continue to coordinate.
Thank you. Ms. Chester is available for commissioner questions.
I'm just going to start with one process thing and then turn it over to my colleagues. The statement of positions will be due, I think, February 27th. So that's 3 weeks from today. Are you expecting you'll be able to get something to the county and the other parties, or at least the county, before then, so their statement of position is responsive? Or do you think we're going to need multiple rounds of statement of positions, or any guidance you can give us towards well, and I'd also say thanks for this constructive addition to the record. So appreciate the quick turnaround and the responsiveness. But just any thoughts on sort of how we conduct the process to get to a commission decision? Ms. Chester or Ms. Kelly? No,
my counsel has some thoughts on that, so I didn't want to
Apologies. We were conferring internally. I think that the company is certainly willing to endeavor to put something together to share with parties in advance. The only complication is the upcoming Elbert County Rule 3700 hearing in 2 weeks. And so we, would certainly try to get something together and timely to the parties. But that's something that we need to. Yeah, and possibly moving the SLP date back would assist with that.
All right. Do you have any guidance? You don't have to decide now, but if you have any guidance before we close the record and adjourn today, that'd be great. Before I turn it over to Commissioner Plan, I just want to check in with the parties. Mr. Martin, do you have, I don't want to reopen a whole round across, but are you all right with this process? Do you have questions for Ms. Chester?
Mr. Chair, I have, excuse me, more questions for you than for Ms. Chester, if I might.
I'm not. Council, help. Go ahead, Mr. Martin.
Actually, more of a comment than in the nature of a question, but I think it would be useful for us as parties to exchange ideas rather than simply end up with statements of positions that may or may not be congruent. But the county is certainly thinking about how they might respond to this, and I believe there's a tentative Board of County Commissioners meeting on the 17th, and I believe the county's engaged, and we'd like to have a chance to at least produce something that we might share with, at least with Excel, and have some conversations about that. I recognize there's an Elbert County hearing, not my fault.
I just say, Mr. Martin, that's all your business. You can, I hope and assume you're going to be talking to the company between now and then. the more the better for us. I think all we can do is set in place a series of deadlines and a process to facilitate that conversation among the parties. Once that's in place, you guys can do whatever you want, submit it, whatever you want. That's at your discretion. So Ms. Dundas, would you say that any different?
Chair, I'm not seeing any reason to let out a process now. I mean, the parties are always able to file a motion to reopen the record, change the procedural schedule, that type of thing. But I think for today, the only point of discussion would be the RRR deadline.
The statement of position deadline.
Or, excuse me, statement of position deadline.
Yeah,
Too many acronyms around here.
Yeah, and maybe we may need 2 rounds of it, depending on how it's structured.
Again, that's something that could be requested for the parties at a future date. I don't know why we would need to do that now.
Okay. Yeah, so I guess there's just one thing we're going to be looking at, setting a statement of position deadline.
And just a reminder from commission decision that was set at February 27th at the request of the parties. I know the parties are eager here to get a decision on an expedited basis. So changing that deadline would of course change when a final decision comes out here.
Maybe.
Chair, we would suggest possibly doing Friday, March 6th as the deadline for SOPs.
Mr. Martin, would that work for you?
I believe so, Mr. Chair.
Mr. Crakes, Mr. Bonas?
That'd be fine for staff, Mr. Chairman.
Mr. Bonas, does that work for you? Ms. Falcone?
Yeah, that's fine for CEO as well.
Ms. Kutzer?
Also for COSA, thank you.
All right. Commissioner Plant, questions for Ms. Chester?
Yeah, thank you. And thanks for coming back, Ms. Chester, for another round. I just had a real quick question. In looking through the hearing exhibit that you just entered into the record, I didn't see there was one bullet point within Ms. Bott's testimony that I had asked about, and it's formalizing coordination protocols and contact points with local fire districts in El Paso County. I saw some outreach around training and things like that, but I did not see that in the, is that something that you were going to potentially include in the SOP, or is that something that you specifically left out of this, or what was?
Sure. I think we had a bullet in the document, the commitments document, intended to kind of address that in a manner in terms of committing to coordinate with the fire districts and OEMs. Well, I guess 2. So one of them is to continue to coordinate to see if they would like access to the Pano AI camera system for the cameras currently installed. That would allow everyone to review the coverage, what areas those cameras can see, and determine if that's a useful tool for them. And then, coordinating as indicated with the outreach to Mr. Hicks, Fire Chief Hicks, in trying to set up good communication protocols specifically about the project, because that'll be a little different than our community resiliency manager, who was also introduced by that communication. And you saw Mr. Hicks indicate he was at the same time typing an email to Mr. Moore. So it wasn't intentionally left out. We had addressed it. We believed in those bullets.
Okay. Yes, I appreciate the outreach to Mr. Hicks. That's just one fire district that happened to show up at our at our public hearing. So I just want to make sure one of the things that staff had recommended was formalized coordination protocols and contact points for the fire districts. And I saw in your bullet points, coordinate with local fire departments and first responders and consult with them to discuss any concerns. But that's a little different than establishing some sort of a formalized coordination protocol. And I just want to make sure that we had that covered.
Sure. I don't know if I get to really ask a question to a question, but maybe
Yeah,
I can
sure.
frame
Yeah,
it this
say
way.
anything you want.
I guess what I'm trying to make sure I'm covering is again, what we were attempting to do is not overlook that ask, but to, of course, coordinate with Tri-County and Big Sandy as well, recognizing that Tri-County has an individual that's a party to this now with Fire Chief Stanwood, and Big Sandy as well, we would coordinate with. And in terms of establishing those formal protocols during construction, that would be in our emergency response plan. In that ongoing coordination, that plan indicates who we would contact, how they would contact us, and those sorts of things. And then our community resiliency manager would coordinate with them about the formal ongoing, not project specific communication protocols. I'm not sure if that's answering your question. That yes, we are going to do that in those two ways, specifically for construction of pathway, and then broadly as a company through our community resiliency program.
Okay, yeah, I appreciate that. And, I appreciate that it might be a part of some other process within this development, but if you could, specifically call it out and as one of the commitments in your SOP, that would be helpful.
Understood.
That's all I had, Mr. Chairman.
Commissioner Goman.
And no, thanks for the clarifications. I don't have any additional questions.
Neither do I. Again, appreciate the constructive response. Thanks for coming back, and I think this time you're free, Ms. Chester.
Thank you. Thank you for having me.
Yep. Mr. Fiedler, are you out there?
I am here.
Can you hold up your right hand, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No, I am on my own.
If that changes, will you let us know?
I will.
Mr. Crakes.
Thank you, Mr. Chairman. Mr. Fiedler, did you cause to be filed in this case the answer testimony of Jeff Fiedler?
Yes.
And if I were to ask you the questions in that answer testimony, would your answers be the same today?
Yes.
Thank you, Mr. Chairman. Mr. Fiedler is available for cross-examination and commissioner questioning.
Mr. Martin.
It will be me, Commissioner. Mr. Fiedler, how are you, sir?
I'm good, thanks. Hanging in there.
Am I pronouncing your name okay?
Yeah, Fiedler. You got it.
Fiedler. Awesome. Well, we've never met. My name is Devin. I'm one of the attorneys that represents El Paso County in this proceeding. Before I believe you're one of our last witnesses, and I, for one, don't want to be the reason why I'm keeping everyone from their weekend. So I'll just jump into my questions right now. But have you had an opportunity to observe the proceedings in this matter yesterday and today?
Yes, I've been on the whole time.
So you were able to observe the testimony of Carrie Parsons?
Yes, I did.
Okay. I just asked because I'm going to be repeating some of the questions that have already been asked of certain witnesses thus far, and I want to make sure that we're on the same page. But my questions for you are going to be limited to your answer testimony, which has been labeled as Hearing Exhibit 401. And if we could pull that up, that'd be greatly appreciated. Could we go to page 7, please? Mr. Fiedler, beginning on the bottom part of page 6, going on to page 7, this is your testimony where you review testimony of Mr. Chester and Mr. Lunar. Is that right?
Yes.
And this is in relation to the information the company provided pursuant to Rule 3703. Is that right?
Correct. Yes.
Okay. Based on your testimony here, you didn't indicate that you had reviewed any testimony submitted by the county. Is that right?
If I'm understanding the question right, yeah, at the point when I wrote the answer testimony, I was reviewing the direct testimony of the company, in its application to the PUC, and, against the 3700 criteria.
Right, but in order to reach these opinions on pages 6, 7, and 8, you didn't review or otherwise cite to any county testimony, right?
Only that was in attachments to the Lunar and Chester testimony that you just mentioned.
Right.
So again, yeah.
I apologize for interrupting you. Please go ahead.
Well, I was just going to say, I think to maybe just repeating what I said before, I only had the company's direct testimony in front of me, but that did include, I think responsive to your question, that did include a number of attachments that, were evidence, I don't know if evidence is the right word, the documentation of the county's procedure, in the county land use decision.
Okay. If we could go to page 8, please. Mr. Fiedler, I'm going to turn your attention to lines 8 through 11 specifically, where you quote from the Commission Rule 3706B that the utility must present reasonable design and siting alternatives to a local government. Is that right?
Yes, that seems an accurate representation of what's there in those lines.
Okay. But Rule 3706B goes beyond the basic siting requirements, including wildfire risk, right?
I don't have the full text of 3706B up in front of me.
But you agree that the company's consultation with local government is essential, right?
Yes, I think I'd agree that I would expect, with any applicant to a local land use, permitting process, there'd be discussion and back and forth.
Right, because that makes sense, right? You would want the company or an applicant to consult with the county about a transmission line going through its land, right?
Yeah, and maybe to elaborate on that, as I think we heard from Ms. Parsons, and also from Chair Geithner, that happens first at the staff level, before it reaches the BOCC in the actual permit hearing.
Yeah, because basically consulting with a local government could help streamline the process, right?
Yeah, or I identify key issues that are part of the code. Every county and jurisdiction's code is a little different, so that back and forth to understand it properly, so the applicant could be responsive. I would agree that's basically essential to have that back and forth.
Yeah. In addition, consultation with local fire divisions regarding in your word, reasonable siting and design alternatives would also be prudent, right?
I mean, that might be getting a little outside of the scope of my testimony. I mean, I think, when I looked at this section of my testimony and the testimony as a whole, it was really about the company's application under the 3700 criteria, not to get into the, procedures or, the nitty gritty of the county's process and how it was handled.
Fair enough. If we could go to page 12, please. Mr. Fiedler, I'm going to focus on lines 10 through 15.
Mm-hmm.
And I should have asked you before, but can you see this okay, or do you need us to zoom in?
Yeah, no, this is great. Thank you.
Perfect. On those lines, you testify that the PUC must balance the local and statewide interest. Is that right?
Yeah, and that's not my opinion. That's just citing, the statute. So
sure. And when you reviewed that statute, it also requires that the PU decision has to be consistent with the 1041 statute, right?
I'm going to
Sure, I'm
object.
seeing that.
We're getting into legal analysis here, and Mr. Fiedler is not a lawyer. The
Well,
county has
he-
already submitted a motion on this. The commission has said we can argue the purported conflict of the statutes in our SOPs. I don't see why Mr. Fiedler should have to opine about it.
If you could rephrase your question, or repeat your question again. Let me hear the question.
Yeah,
Or
and just
rephrase it.
I apologize, Commissioner. Just for sake of clarity, Mr. Fiedler bases a lot of his opinions on the review of the statute. So my question was whether the statute contemplates and it has to be consistent with the 1041 statute. So based on his review of a statute that he relies on in his own testimony, I think that's a fair question. But I'm happy to rephrase it to avoid an objection. It's going to ultimately get to the same conclusion.
Yeah, if you would rephrase, that'd be better. It does appear like you're asking for a legal conclusion with that phrasing. So I'd sustain the objection, but encourage you to rephrase.
I'll avoid that, Commissioner. I'll just move on. I appreciate it. Focusing again on page 12, Mr. Fiedler, specifically lines 13 through 14. You testified that local government's decisions are entitled to considerable deference. Is that right?
Well, I think the whole sentence is good to read there. It says in general. I think the phrase in general is doing a lot of work there. And I think it really should be read in the context of that whole paragraph. I think my intent, as I read that last sentence about considerable deference being given to local control, which includes local permit citing, was really just to make the point that this is a pretty special case here in the 3700 rules where we are, where, as I said elsewhere in the testimony, there is tension between the statewide interest and the local government interest, sort of as said in the statute. So again, I think that last sentence really needs to be read in the context of the whole paragraph.
Sure. And in relation to the whole paragraph, it's basically a summary of Rule 3703B, right? That states that companies' applications shall include the basis for the local government action. And further, Rule 3703B 13 requires information on the impact the proposed facility would have on residents within local government's jurisdiction. I could read on, but it looks like this paragraph, as you suggested, needs to be read in context. But in relation to an interpretation of Rule 3703, you testified, and these are your words, that considerable deference is given to Colorado to local control. Isn't that right?
In general.
Okay. If we could,
and just to come back to the earlier part of your question.
I appreciate that, Mr. Fiedler. I don't have any question for you, but if we could turn to page 17, please. Mr. Fiedler, I'm going to focus on lines 14 through 17, so towards the bottom. You could scroll down.
I don't know if oh, there we go. Okay. I don't know if that was me freezing or, yeah.
I didn't want to repeat, but can you see that okay, Mr. Fiedler?
Yeah, 14 through 17 is up. Great for me.
Okay. As a point of clarity, 14 through 70, so staff also recommends, based on the discussion in this section, that options to mitigate. When you say staff here, do you mean PUC staff or do you mean county staff?
Oh, PUC staff.
PUC staff, perfect. Could we go up to 16, please? Specifically lines 6 through 8, you state second staff, which I interpret to mean PUC staff. PUC staff observes that the county staff report presented in the BOCC did not recommend denial. Did I read that correctly?
Yes.
You understand that county
I'm
staff.
sorry. Can we have the whole sentence read instead of half the sentence? That sentence goes on to state, and found that the company's application met the county land code criteria. We're taking things out of context here.
I appreciate you reading that into it, but to that first part, Mr. Fiedler, you understand that county staff don't make recommendations to the Board of County Commissioners, right?
Well, I understand that now. I mean, I did listen to Ms. Parsons' testimony and also saw her answer testimony, but when I wrote this answer testimony, I did not have Ms. Parsons' statement in front of me.
Okay,
yeah.
No, I apologize, Mr. Fiedler. Please go on if you had more to say.
Well, I mean, if I was to rewrite, or if I was to write this now in light of Ms. Parsons', answer testimony, the sentence would be more nuanced.
Absolutely. Would part of that nuance be that in the absence of a staff recommendation for denial or approval, that ultimately what's included in the staff report doesn't reflect the Board of County Commissioners' opposition or approval? Would you agree with that?
Could you say that again? Sorry,
that was a really poorly worded question. So thank you for.
No, I was reading some lines in here again, and I was multitasking.
No, for sure. In the absence of what you considered a staff recommendation, but we've clarified that county staff does not make recommendations. You understand now that the staff report that was submitted to the Board of County Commissioners decision, that doesn't reflect one way or the other the board's ultimate opposition versus approval, right?
Yeah, I totally agree with that. And I should mention I was a county commissioner for 4 years and have been in this position. I totally understand the difference between the BOCC's role as making the actual decision, that is reflected in their final, resolution and the motion they vote on. And that's very different than the staff work in bringing a staff report, before the BOCC. So I think that was a long way of saying yes to your question.
Well, no, I appreciate your insight nonetheless. Thank you, Mr. Fiedler. If we could go to page 18, please. Well, I got ahead of myself. Do you mind if we go to page 17 first? I do apologize. Mr. Fiedler, I'm going to focus on lines 14 through 17, so just a little bit further down on this page.
And again, I would object and ask that the entire sentence be read. It starts on line 12.
I haven't even asked a question yet, but I will endeavor to read the whole sentence. So to your attorney's point, I will read starting from line 12 all the way down to line 16 or 17. So you testify, while staff recommended in the previous section that the commission should approve the company's appeal, even without further mitigation of local impacts, staff also recommends, based on the discussion in this section, that options to mitigate or compensate for local impacts be explored beyond what appears in the local land use decision, period. This approach is discussed further in the next section, period. Did I read that correctly?
Yes.
Can you expand on that? Can you provide me any additional information to support lines 12 through 17?
Yeah, I think first I'd look at the statute that, we were talking about. I think it was page 12, but we don't have to go back to it, but just the statute, which specifically says that the PUC's role here is to balance the statewide interests and the local interests. And I think what I was trying to get to in this sort of whole section and then in the sentence that you read out here is, that in balancing the local interests, you should understand what those are, what the local concerns are, which is why this section does get a little bit into, the local land use decision. But I think, this recommendation on, what is it? Pursuing options to mitigate or compensate for local impacts, that to me, that is just reflective of that balancing between statewide and local interests, that the statute requires of the PUC. And I think it is a shall in statute.
Yeah, I'm so sorry to interrupt you, Mr. Fiedler. But as you sit there today, is this still a possible way for the commission to balance the local and state interests?
What is this? Sorry.
So, yeah, maybe I got ahead of myself, but based on your discussion throughout this section, do you see a possibility to kind of resolve and balance and implement that balance with the local and state interests?
Well, when I wrote this, and I think, as it says in the next section, and I think at the time, that procedurally could have been pursued in settlement discussions, as often happens in proceedings. I think, as we were just talking about with Ms. Chester, I think we, procedurally we're in a different place than when I wrote this recommendation and, elaborated on it in the next section. I still think trying to find a resolution would be good.
Of course. Would you mind turning to the next page, page 18, please? And I believe this is a complete sentence, but I'll let your attorney correct me if I'm incorrect. But your lines 8 through 10, do you see where I'm referring?
Yes.
You don't need to read it out loud, but in your view, the commission's role is to seek an equitable resolution of the tension between state and local interests to the extent possible, right?
Yes.
Could we go to page 22, please? And I'll direct your attention to lines 20 through 22. Can you read that okay, Mr. Fiedler?
Yep, all good.
Specifically the sentence that starts with identified.
Yeah.
So you testified that identified impacts and concerns include wildfire mitigation, emergency response capacity, and induced leapfrog development. Is that right?
Yes.
On to the next sentence, you go on to say that some of these items may be addressed through upfront, direct committed expenditures on specific equipment or programs, and for example, wildfire mitigation contracts, wildfire detection equipment, and emergency response equipment, right?
Yes, that seems like an accurate reading.
Okay. Could we go up to page 21, please? Lines 16 through 17. And to stem and to go back and relate to that later testimony in on page 22, you testified that a legally binding community benefit agreement would be one way to resolve that tension, right?
Could we scroll down so I can see footnote 53?
Yeah, absolutely.
Oh, great. Thank you. Yeah. I mean, that's what the sentence reads. It is, it's quoting the state energy office report.
And then going back to page 22, lines 18 through 20, please. On these lines, you encourage the two parties to pursue further mitigation actions that address the local impacts identified by the county, right?
Yes.
Okay. Such as wildfire mitigation and emergency response, right?
I mean, I think that's, those have come up again and again in this hearing and in the, in the testimony. So yeah, I think those are reason why that's probably not exhaustive, but yeah.
Sure. Mr. Fiedler, I have no further questions for you, but I really do appreciate your time.
Great, thank you.
Commissioner Plant, any questions?
I have no questions for Mr. Fiedler. Thanks.
Commissioner Goman.
I also have no questions for Mr. Fiedler.
I have one question for you, sir. On page 21 of your answer testimony, you discuss community benefit agreements. We don't have to pull it up. Earlier today, for purposes of fleshing out the record, the company presented a list of conditions that it might be willing to commit to meeting. Any advice for us, the company or the county, to sort of achieve the goals you laid out in your answer testimony?
I mean, I think
Advice,
for,
thoughts?
yeah.
Yeah.
Oh, sorry. Well, I
No,
think first,
go ahead.
I mean, pretty new to looking at that document. I'd really, yeah, definitely appreciate the chance to circle back with colleagues and have a chance just to reflect on it more. So this is a very preliminary answer. I mean, I think I may just reflect, I actually forget who was speaking, but I mean, I think there is a lot of good material in there. I mean, it reflects some conditions that were discussed in the county proceeding. Again, it's probably not exhaustive when you look at all the concerns that have been raised, you know, the sort of local impacts or concerns that have been raised in this proceeding. It might not be exhaustive.
All right, that's all I had. Mr. Craig's redirect.
Yeah, just very briefly, Mr. Chairman. So, Mr. Fiedler, you were asked about a section. It's on page 12 of your answer testimony. If we could please pull that up. And starting, you were asked, I believe, about lines 10 through 15. I just want to have you take a look at this entire paragraph. Starting on line 10, you say, pursuant to the underlying statute, the Public Utilities Commission shall balance the local government interest with the statewide interest, and therefore the local government interest must be fully considered by the commission. In general, land use permitting authority resides with the local jurisdiction, and considerable deference is given in Colorado to local control. Have I read that accurately?
Yes.
So based on this, is it your position that the commission has to balance the statewide and the local interest?
Yes, I think that, I mean, that's just the exact language from
And
the
so
statute. Yeah.
is it fair to say that the local interest is not given greater deference than the statewide interest here in this balancing act?
Again, not a lawyer, but you know, it says balance. You know,
Just asking about your position. Yeah.
It doesn't to me, there's no statement of one having primacy over the other.
Okay. You were also asked about whether you reviewed the county's testimony in this proceeding before making the recommendations in your answer testimony. Do you remember that exchange?
Yes.
And I believe you said you did not, correct?
Correct. At the time of writing answer testimony, there was only the company's direct testimony.
That's what I'm getting at.
Yeah.
It's fair to say that the answer testimony of the county was filed on the same day as your answer testimony, right?
Yes.
So it would not have been possible for you to review that answer testimony before making your recommendations in this case?
Correct. Yes.
All right. I have no further redirect, Mr. Chairman. Thank you, Mr. Fiedler.
Thank you, Mr. Fiedler. You may be excused.
Thank you.
Any final issues before we adjourn and close the record? Ms. Caliendo.
Just a very brief one in relation to the statement of position. In addition to extending the deadline to, I think it was March 6th, we also wanted to request an additional 5 pages in the statement of position to make additional room for the discussion of a potential impact fee proposal.
And any objection if that 5-page addition applied to all parties?
No objection.
Any objection to extending the page limit? Mr. Martin, Mr. Crakes?
No
objection from staff.
No objection, Mr. Chair.
No objection. No objection.
Thanks. Any other final matters before we adjourn?
Nothing else. Just wanted to express our appreciation to the parties and looking forward to working with all of the parties in the county on a potential proposal on an impact fee.
Well, I'll just echo that appreciation. Thanks for getting us through the hearing. Thanks for the constructive and collegial approach by all the parties. Greatly appreciated, and sounds like we're going to do this again in a couple of weeks. Commissioner Plan, any final thoughts?
Yeah, I just would echo that. Thanks a lot for the hearing, and appreciate everybody's participation.
Commissioner Gilman?
Yeah, likewise, appreciate all of you, and many thanks to our counsel and legal assistants who keep this machine running. So thank you so much.
Yeah, and apologies for going late last night. With that, thanks again, everybody, and we're adjourned. Have a great weekend, everybody.
Thank you, Commissioners.
Thank you.